Vicky, or I guess it's Vicky, not Kim. Can you do our housekeeping?
Of course.
Thank you.
So welcome committee members, liaisons, and members of the public to the Legal Services Trust Fund Commission Eligibility and Budget Review Committee meeting. Thank you for joining us. We are using Zoom with the goal to foster a more inclusive environment and effective meeting. If you would like to comment during the meeting, please type "I have a comment" or "I have a question" in the chat, and a message will be sent to the host. Alternatively, you can also use the raise hand feature. In efforts of transparency for all those joining this public meeting, whether by phone or Zoom, we request that you refrain from having side conversations on chat about the content of the meeting. Again, the chat feature is utilized simply as a tool for you to virtually indicate that you would like to speak in order to help the chair facilitate the discussion. A reminder that going forward, all Legal Services Trust Fund Commission and committee meetings are being recorded and will be posted to the State Bar website. For those using Zoom on a computer, when on mute, holding down the space bar will temporarily unmute. If you use your phone to dial into this meeting, please be sure your computer's microphone is on mute to avoid audio feedback issues. And lastly, while joining audio via computer is highly recommended, if an individual loses audio, they can call in separately using the Zoom conference number.
Great, thank you very much. Erica, do you want to take roll?
Sure. All right. Connolly?
Here, sorry.
Klage? Fight Master? Bennett?
Present.
Blakemore?
Here.
DeBose?
Present.
Delfino?
Here.
Friedman? Mann? Meeker?
Here.
Plantold?
Here.
Savage?
Here.
So we have quorum. Yeah.
Okay.
Oh, and I'm sorry, I can go through liaisons and stuff really quickly as well.
That'd be great. Thank you.
Selena Copeland from LAC.
Erica, Selena's not here, but I think Zach is an attendee on probably behalf of LAC. I see him in the attendee.
Thank you.
I've been promoting him to, excuse me, I've promoted him.
Jeez.
Hi there. Yeah, Zach attending for LAC.
Thank you. Bonnie Huff from the Judicial Council.
I'm here. Thank you.
Christine Ganong. Mark Tony. And then staff. Dawn Nguyen.
Here.
Here. Michael.
Here.
Is there anybody I missed?
And Brady's not joining us, but he said he's on call. We have a legal issue. So if something comes up, I can just text him to come on.
Great. Thank you. Are there any members of the public that would want to introduce themselves or make any comments at this time? Okay, hearing none, why don't we move to our the first order of business, which is the approval of the meeting summary and action items from February 26, 2021. Oh, one sec, Bob. Does anybody have any comments on it or any concerns? Okay, Bob, you want to make your motion?
Parliamentary procedure, you should first have a motion before you take comments or concerns. So moved.
Any comments or concerns now? No? Anybody want a second?
I'll second.
Okay, I'll give it to Herman. And Pamela, I think I saw your.
I was doing the second, so that's okay.
So you can do the next one. Okay, let's go ahead and take our vote.
Connolly.
Yes.
Klage. Fight Master. Bennett.
Yes.
DeBose.
Yes.
Delfino. Delfino.
Yes, sorry about that. I was trying to get unmuted.
No problem. Friedman? Mann? Meeker?
Yes.
Lantle?
Yes.
Savage?
Kim, we can hear you.
Cameron Stewart.
Yes. Thank you.
It passes.
Great. Okay, let's turn to business. So Erica, do you want to provide us the update on the webinars for the IOLTA and EAF applicants?
Sure. So we just wanted to update the committee on efforts that the office has been making to reach out to prospective applicants and provide information before the application period to help streamline the process. So we conducted some outreach and had a webinar back in March with, I believe, about 18 to 20 organizations registered. Actual attendees, I think, were a little over 30. So that was a really good turnout. We provided just an overview of the grants, the application timeline, the eligibility requirements, reporting requirements if you were found eligible, and just, general TA about the process. And then a few weeks ago, we held a follow-up sort of question and answer session for prospective applicants. And so a few organizations attended that as well. But even since that time, since we held the first webinar in March, we've had several other organizations reach out. I think Vicki told me that we had 4 new ones within the past 2 weeks. So remains to be seen how many new applicants we'll have. I think I counted yesterday. It looks like there's about 10 new ones in draft form, but we'll know next week how many actually come through. So it's just something, to keep in mind when the committee meets next. We'll be in ILT EAF application review period. So.
And this was an idea that came from this committee, is to have a webinar, a preemptive webinar, because we were getting so many applications that would go, submit an application, and then they would get to eligibility review conference, and some of the baseline requirements were missing. So this is an effort to kind of be more transparent with our process, and the guidelines and the statute is just very confusing for a new applicant. So we found that everybody had really good questions, and so I think it's been positively received, and Erica's been doing a really good job running the webinars.
Great.
Do you anticipate this being an annual?
That's what we imagine. I mean, I think at some point, maybe because we record, at some point, maybe we recycle the recording, but I don't think we're quite there. We want to refine it, and we want to put together an FAQ. We're looking to kind of do a facelift on the website as well, of really pare it down on what's required and what's not. There's a lot of information, but there's still a lot of kind of confusion over IOLTA and EF application process.
Yeah. I mean, I think it's great that you guys are doing this. It's a good way to educate the organizations on the front end. Other thoughts or comments? Okay.
And then just also related to that, sorry, Erica, just one more.
Please.
In addition to that preemptive webinar, we're holding a webinar, the Judicial Council, LAC, and the State Bar for new grantees in 2 weeks. And that's also open to new leadership at organizations, because every year there's kind of a turnover. And so we do kind of a refresher, and we let them know, again, what baseline requirements are, what's expected on a monitoring visit, what are the kind of resources that LAC can provide in Judicial Council, and how kind of the 3 entities work together.
That's great. Hopefully help us on their applications and us in reviewing. Great. So if with the committee's indulgence, I'd like to take things a little out of order and actually move to the eligibility review conference discussion, just because it's something that was on our last agenda, and I think the iLaw stuff is going to be a little bit meatier. And so I wanted to just initially get some comments and feedback from the committee about how the ERCs went last year, what your thoughts are about when you want ERCs, and Erica, if you want to maybe give some more details about what you'd like from us, that information.
Sure.
Erica, also, could you give a little bit context, because there are some new commissioners on this committee? That would be helpful.
Sure. For anybody who hasn't participated before, the eligibility review conference is something that we hold often when we'll have new applicants or applicants that have eligibility concerns when staff first reviews their ILT-EAF application. It's an opportunity, particularly the new organizations, to learn more about their work and clarify some of the questions that are coming up both for staff and the committee members and making a determination on the application. So we will typically be in conversation with the organization, seeking information beforehand and provide that to the assigned committee members. It's usually 2 or 3 committee members as well as staff who attend the conferences with the organization. And then after meeting with them, getting more information and comparing it with the governing authorities, a memo is prepared for the full committee when making decisions on eligibility or in terms of making a recommendation to the commission. The main purpose is to get more information to make that determination and to have a solid foundation for making those decisions. But it's also an opportunity to provide some education, particularly for newer applicants, about the purpose of the funding, ways to meet the eligibility requirements or demonstrate that they are meeting them, and to correct any deficiencies in their application. So last year, I believe we held eligibility review conferences for 6 of the 7 new applicants. And all of them were new applicants last year. There weren't eligibility concerns with existing grantees. But we just wanted to get a sense of, we know last year it was really a compressed timeline and there were several of these meetings sort of back to back. So we have a little bit more breathing room this year and ability to plan ahead for these. And so just wanted a sense from those who did participate last year, what worked well for you. If there are issues that are, very obviously like potentially disqualifying, like an organization not being incorporated in California, is that something that you want to have?
That was funny.
Yeah, do you want to have an eligibility review conference because of the value for educating the organization, or are there other means of kind of addressing those concerns while prioritizing efficiency? That's kind of what we're looking for from you, about just some feedback about your experience and if there's anything that worked really well or didn't work well from your perspective.
I'll start by, it was excuse me, a little scary. Just to kind of to put on the spot, just to kind of let them know what we expected based on, again, the rules and regulations and different authorities, but just kind of hearing from them, asking specific questions. Sometimes the answers were evasive. So it was interesting to really get a sense of who they are and how they presented their material and how they were going to meet the needs of the clients. So it was very helpful on my part. I trusted my peer group. And so it was good. It was good for them to be able to share with the commission and the committee what their goals were, what their intent for their purpose, whether this is why we want the funds, and we're going to stick to these rules, and we're going to stick to why we say we want them. And if we deviate, here's why, a very real response. So they were very helpful, very educational for me. So.
I did one last year, and a lot, like Pamela said, I got a lot out of it. I think the sort of the face-to-face, whether it's Zoom or in person, you get a good sense of who these people are, how they answer the questions. I think that there are ones that we probably, like there was one that wasn't incorporated in California, if I remember correctly. It was just a no because it didn't meet the requirements anyway. I mean, something like that probably isn't worth spending our time on. But others that have look, promising, but we have questions, I think we should do them. I got a lot out of that one.
And Louise, just to a little bit of context, like because staff were not really an authority to make a determination. So usually programs have several screening calls with either Erica, myself, or somebody on staff, and we give them the general requirements. And in that particular situation, we did tell them they had to be incorporated, but they were insistent on going through the process. And as staff, we don't have the authority to say you don't qualify. So we had to take them through the process, knowing that most likely, very likely, or they wouldn't, but we just couldn't give them that determination outright. And so that's where it was a little bit tricky. And they weren't the only organization. There was another organization. We knew that they were going to be below 50% qualified expenditures. And we had really frank conversations with them. But they were very insistent to submit an application. So we let them submit an application. And then the other thing is, I don't know if you recall a couple of years ago, where staff made a recommendation, and then it was existing programs that went up in appeal, and then the commission reversed it. So I think as staff, we appreciate a second pair of eyes, even though sometimes it seems kind of clear cut. And so that's why we were hesitant to not to say definitively, don't apply or you're not going to qualify, because it could go the other way. So that's kind of our struggle. We're happy to be more, I guess, preemptive in saying a determination or predetermination, but I don't know if a staff alone would be comfortable with that. I think there was suggestion last year that maybe the chair of eligibility could then have a meet and confer separately in those instances. I don't know if that's you would be amenable to that.
This is Bob. I wanted to offer a concern that we've got many more.
Sorry, Kim, I'll get you in just a second.
requests. We've got many more new grantee requests, which could be much more staff time. This may be something for our rules committee to consider, that we specifically require that a grant applicant be incorporated in California. That could automatically have reduced that one person. And secondly, that maybe the applicant show proof that their qualified expenditures meet the 50% criteria, so that if it doesn't, and they say to staff, that staff can work with them simply on the 50%. I'm suggesting we don't have increased staff, but we've got increased demand. We've got increased amount of time that needs to be consumed. And some of these that clearly don't make the cut, but for which staff lacks authority, it burdens you and it slows down our meetings. Our meetings get delayed or get backed up, or we might have to have multiple sessions because so many grantees are just, fighting to the last minute when they're really not eligible or qualified. I'm suggesting there may be some hard and fast rules and maybe guidelines that staff can inform applicants about, so that applicants who aren't incorporated California can just say, okay, and go away.
Yeah, I think in that situation, staff had informed these particular applicants, but because they don't have the authority,
that's what I'm saying. Staff ought to have.
They do
something.
inform them, but these guys decided to continue with the applications regardless. I thought the ERCs were a helpful way to provide some information to them and a little bit more directly. Sorry, I know Kim had her hand raised, and then Catherine, I'll get to you as well.
So, the topic right now is really in regards to the eligibility reviews, and I want to comment on that. But first, I just wanted to say that I think that the trainings that you are offering are going to go a long way, hopefully. And I think that, I'm not sure if you are requiring this or if you can, I think you probably can require that any new applicant attend some sort of training initially to understand the basics, so we avoid the situation. The example we keep bringing up again, which is like a no-brainer, I hate to say it, So I know, for example, in the city of LA, if you're going to apply for funding for many of their RFPs, you are required to log in to a session which explains the RFP, what the requirements are, all of that. I think you guys understand where I'm heading. I think you should do this with new applicants. I think it might save everybody a lot of time. I'm just hoping that thing with the being unincorporated not incorporated in California was just a really outlier. I mean, just was such an obvious thing that, and the individual did apologize later, but it's a little too late. So what I want to go back to now is the eligibility reviews. So I don't think I did any of this last year, but I have done them in previous years. There's, to me, an important factor in doing them, which nobody has brought up, which is for us being very positive, diplomats or representatives of the state bar. We need the program. We know, for those who've been on for a while, we know that we need the programs to support the Legal Services Trust Fund Commission, because there were attempts to eliminate it completely. So I'm all for making sure that rules are followed, but I do not think these conferences, certainly as a trust fund commissioner, should be a get you kind of thing. They should be positive. They should make the rules clear, but they should really be a way for programs to understand kind of what our role is, and that we are committed to supporting these programs and the work they do. So I just don't want to lose that element that I think is really important on these conferences.
Great.
I'm getting off my podium now.
Very helpful. Catherine, you have your hand raised?
So I just wondered if there was just like a sort of a more simple way to resolve sort of the basic eligibility questions, which, but maintaining, I understand staff doesn't have the authority to make a decision. So could there just be 2 commissioners, for example, that reviewed the staff work? And if it's something as basic as you're not incorporated, decide if they want to talk to the program and tell them that directly, because that seems like an important part of the process, or, or make that decision and that recommendation that's then going to go without meeting with them. But it just seems like you could just have a shorter process that had some oversight, but did not involve the same amount of time. And people were clear that their role was just in this sort of core requirements area, and kind of kept everybody else out of that. Just, choose the chair and one other person if the chair wants one other person to be involved in that.
Yeah. I think there might be a way to kind of streamline the ERCs, but I think Kim's point, I was in that ERC with the unincorporated. I actually, as much as I was a little bit annoyed that they were pushing it, I actually thought the ERC was a beneficial experience, right? We talked to them, we gave them here are your options. You could incorporate, right? We educated them in some ways about there are ways for you to accomplish this. It's just, and they said, well, we're not quite willing to do that. And we were like, well, it was a good opportunity for us to say, we don't have discretion here, right? And to educate. And that might be, Catherine, to your point, something that, the chair could do, right? It could be, it was a fairly quick conference in some ways. It wasn't actually that much time, right? We talked and we chatted with them and then it was done. But I will just say, I do value having kind of they're more informal than these meetings, an opportunity to kind of talk through these things with them. And
yeah, I think I was just looking for ways to streamline it, particularly if there's going to be 10 new applicants and there's 2 of them that maybe just don't meet the basic ones, let people focus on the ones where you want to do that larger engagement and find a more streamlined way to have a discussion, but not make it the same, the same number.
And last year we had thought about maybe the staff could come out with a couple of these baseline requirements, like the incorporation, having an audit, because we do often get programs that go through and they don't have an audit, and that's a baseline requirement. So those are the more obvious ones. It doesn't have to be an exhaustive list, but something that's at the front end. So Erica, Carol, and I can probably come up with something by the time we meet next present to you.
Great. Bob, you have your hand raised?
Yes. As much as we just heard a staffer say that this one conference was relatively brief, my response is, but look at the reality. You're blocking out X amount of time. Just like today, we're told this is going to be likely a short meeting, but you staff and we've blocked out 4 hours. So when you block out time, even if it's, let's say 20 minutes, you know, you could have scheduled in something else for the remainder of the time allotted. And as far as, again, codifying restrictions, and I'm using that broadly, I still think making some hard and fast requirement, you got to be incorporated, you got to have an audit, is worthwhile pursuing. If not that formally, then at least maybe in boldface type at the beginning. In order to actually qualify to apply, you need to be incorporated in California. You need to have an audit. You need to have this. Don't just have it in the type of a paragraph, you know, buried somewhere. Boldface it right up front at the beginning. And to me, that's a weak alternative to a hard and fast no set of restrictions.
Yeah.
Again, you're taking time to answer there, but we do good work in California. Yes, agreed, but that's not what the law allows us. And to that extent, I'm looking to help you folks with, if you will, making time for other important activities that you put aside for these conferences. And so if you're going to come back with something next time, think about whether you want to suggest, you know, a hard and fast no. Because even if you say we'll have the chair and you know, a designee, that takes up those person's time to do the follow-on. No, you can't apply. No, you're not eligible. And it's just like we're bending over backwards in multiple loops almost to avoid somebody saying, I'm doing good work. You ought to look at funding me. When really they don't qualify. So please, at least come up with maybe 2 options, if not 3, of specific restrictions, boldface the information up front. And then to me, the weakest alternative is authorize the chair and the designee to also then meet, which would be a simple me too follow up from them to what you staff are saying. So I'm done on this one. Thank you.
Okay. Other thoughts, comments? Okay. Well, it sounds like we have some interesting ideas about maybe figuring out a way to require training on the front end for new applicants. I thought that was a good suggestion. To Bob's point, like coming up with certain criteria that maybe if their applications don't meet those criteria, they're not, you kind of say, well, we're not going to even do an ERC, or, you know, doing like a meet and confer with the chair, something that's like a little bit more streamlined. But it sounds like that's helpful. Yeah, Bob, what's up?
Your phrasing triggered a thought. Just because they don't qualify for an ERC, couldn't they still take the training to learn more about the program and what its requirements are? To me, that seems feasible. Take the training so that next time you're better prepared to apply or not, even if you can't apply now. Let them know the training.
Yeah, and any applicant must attend this training in whatever way we're doing it, a webinar, whatever. Yeah.
I just wouldn't want an applicant to feel, because we're telling them no, that they can't learn more.
Right.
They're a potential applicant in training.
Yeah. Okay, Erica, Dwan, is that the feedback? Any other questions that you have for us on this stuff?
No, that was very helpful. Thank you.
Okay, so now into the meat of our meeting, which is these ILAW reports and how we want to deal with some of the potential qualified expenditures and stuff. So I think, is it Erica, you're gonna take this one? There's a presentation.
Yeah, Dwan and I will.
Oh, okay.
And
Ron,
as
do you want to-
Erica, pulls up the PowerPoint, I can give a little bit of context on the background of these ILAW reports. So our office rolled out these impact litigation and advocacy report that are required from all grantees three years ago. This is the third cycle that we've that we're reviewing them and bringing them to your the committee's attention for approval. Previous to that, programs didn't have to submit, ILAW reports. What would happen is during the IELTS and EF application, certain programs would submit their litigation docket and their top 10 advocacy work. And we would review it to see if they were qualifying, and if there are questions about it, then we'd elevate it to Eligibility and Budget Review Committee. But over the years, it was the same, I think between 7 and 10 programs that submitted a litigation docket, and other programs didn't. And over the years, it kind of evolved, because as we went on site visits, we knew that these programs had a heavy litigation docket, but it had felt unfair that 10 of our 100 programs are submitting litigation dockets and the other 80, 90 programs were not. And over the years going on monitoring, we knew that there are some programs that had heavy litigation docket and advocacy, and some of the activities were questionable. So then 3 years ago, we designed this impact litigation advocacy work report that said that programs had to submit their top 15 impact litigation and their top 10 advocacy work activities for the year. And the reason was twofold. Was to make sure that those activities were qualifying, and then also we would take highlights from these litigation and advocacy work and roll it into our impact report that we be publishing periodically. However, what we didn't anticipate at the time was it's very time consuming reviewing these reports for grantees, as well as on the staff side. There was a memo that was attached to your the meeting agendas today, and you'll see in the memo that we reviewed 410 impact cases and 447 activities. So for each kind of activity, the programs have to submit an individual report. It's very time consuming on their end, and it's very, very time consuming on our end. And I would say over the past 3 years, there has been a lot of back and forth with staff and this committee with the program. So we actually don't have a lot of activities to elevate, because we've come to a good understanding between the programs of what's qualifying, what's not qualifying. However, we still have to have these meetings, because some of the practices that we've adopted over the years is not codified. So as staff, we don't have the authority to approve some of these cases. So we're going to be bringing them before you for review. But just know that what we're hoping, though, the rules committee, as they figure out and have a better definition of what is legal services and how to demonstrate indigency in the program's work, that maybe we phase out of this type of ILAW report, or really redo it, just because it's a lot of time and effort for you'll see there's not that many questionable activities so we don't know if it's kind of worth the cost benefit analysis. And Erica, Carol, and I were talking, it is just an ornament amount of work for us to review this, and it really was well intentioned in with the idea of being equitable across all programs, but the cost benefit, I'm just not quite sure it's worth it. So that's kind of the background of the ILAW reports. And I'll take a pause there to see if there are any questions, because I know there's some newer committee members.
Anybody have questions or concerns?
Okay.
I had several questions about the organizations that were presented, and so I kind of compiled them. I'll just put them in the chat and let you see what they are, and you can address them if you want to. It's okay.
Yeah, so
How does-
Pamela, I think we're going to actually get into each of them
Right?
like
Okay.
in more detail. And so I think it'd be good to ask to like address your questions on each
Each one. Yeah.
program. This is just more like on the background part of it, but yeah, I think it's great that you have questions on them, and we can address them as we go. Is that okay?
Yes, ma'am.
Okay. Okay.
Okay.
It sounds like we can move forward.
Just a really brief refresher on kind of the governing authorities, and they were included in that memo that was attached. As you all know, a qualified legal services project and a support center, they have different primary purpose requirements. For QSP, it means that they have to be, their primary purpose has to be to provide free legal services to indigent Californians. And then, as you all know, there's a very specific definition of indigency. However, you know, the definition really goes to those individual cases, and not, it doesn't really address impact cases. So if a client comes to the door and they're below 125, or you know, they're senior, or they have a developmental disability, that's easy to screen and know that whether they're qualifying or not qualifying. The issue that we run into with the ILAW reports and ILAW cases and activities is that what happens in an impact case or a class action where the named plaintiff or the class isn't obviously indigent, and for various reasons, sometimes programs pick a named plaintiff or a class, and it's for strategic reasons, and it's not obvious to us that it's indigent. How do we then qualify that? And it's the same with advocacy activities. Sometimes the advocacy work can benefit the general population or a larger group. At what point is that, do we count that qualifying for the purposes of the IOLTA statute? Erica, you can go on to the next slide. And then here's the primary purpose requirement for a support center, which has a different focus, as you all know, because support centers provide the support services for the QSPs and the legal aid community in general. So their primary purpose is the provision of legal training, legal technical assistance, and advocacy support without charge. And they actually have to provide that through an office in California, a significant level of the same support services. So there's really not that requirement of it being their work being indigent, though, you know, obviously the vast majority of the support services they provide would benefit indigent clients. There's just not that indigency requirement. It's not as obvious. So they have a lot more leeway. And then, as you all know, our state bar rules, if their qualified expenditures are 75% or more, then they're presumed to be qualifying. And so with the ILAW reports, if you make a determination that an activity is not qualifying, then we do ask them to then deduct it out of their IOLTA and EF application. So we do this the first year that we rolled out the ILAW report, we were reviewing the ILAW report at the same time we were doing the IOLTA and EF application. And it was just really too much for the commission staff and programs, because they would have to answer questions related to the application as well as ILAW. So we moved up ILAW the last 2 years to address the ILAW issues. And if the committee comes with a determination, then we'll ask programs to then deduct it on their IOLTA and EF application, either on the back end, or sometimes we conclude it earlier, then they'll do it before they submit an application. This year they won't be able to, because the application is due next week. So we don't if we don't come to a resolution, then staff would reach out back out to them during the application to have them deduct it. And then obviously if they fall below 75% of their total qualified expenditures, it'll come to the committee to see if you would like to call an eligibility review conference with the program. So it's you know, it does impact their grant allocation, what you deem today to be qualifying or not qualifying. The state bar rules does have a definition of legal services as well as legal support services, but again, it doesn't quite address the issue of impact litigation and advocacy support. And this is something that the Rules Committee, and I know there are a lot of purposefully, a lot of Eligibility and Budget Review Committee members are on Rules Committee because we are going to be dealing with these foundational issues later this year. So now we're going to transition a little bit and talk about what we call the substantive buckets. So there are a lot of kind of activities, both impact litigation and advocacy reports that staff has kind of categorized into these substantive buckets. And last year, we elevated these kind of substantive buckets for your review collectively because of there's commonalities. It just didn't make sense to elevate, you know, 100 cases individually when there's commonality. And these kind of areas, what staff is recommending is approval because there is some demonstration of it benefiting low income and underserved communities. So we'll go through them. And again, it's pretty mechanical just because you've already approved it last year. And I think the leaning that was expressed from this committee as well as the commission is if we've already approved an activity for a program, we shouldn't undo that. That would be a hardship for the program. But because this isn't officially codified, we do have to bring it to your attention again this year. So the first bucket that we want to elevate again, that was already again pre-approved last year, is affordable housing. So we have 168 total activities, 91 of them are advocacy and 77 litigation. And then these instances, a lot of times the program is not able to have data that demonstrates that and what the office practice has used is if programs can provide data that shows that more than 50% of the activities, more than 50% from their activities, more than 50% of the community would benefit that are primarily indigent, then it would be qualifying. If that's not codified anywhere, we actually would like in the rules committee to move away from that standard, but that is the existing standards, existing office practice. So if programs are able to provide data that shows that, then we don't elevate it to your review. But if they can't, and in a lot of these cases they can't, and that's why they're grouped into this category. But we do think, and we believe, and I think the commission shares this, is that a lot of affordable housing work does disproportionately impact low-income communities and clients. And so for that reason, with the impact work and the advocacy work, we should count as qualifying. Oh, so I don't know if there are questions. Our thought was to go through, I believe are there 8, Erica, or 9 buckets, and then have you do a motion at the end to approve it. But we are happy to discuss each one as we go along.
Yeah, there are 6 categories.
6 categories.
Looks like Bob has a question. His hand raised.
Regarding the logical assumption that work on housing is benefiting or affecting people with low incomes, I agree, but how defensible is that? I know, here's an example from 20-some years ago in San Francisco where the opportunities to get money for low income or affordable housing were only sent out to nonprofits, and a industry trade association of private builders complained, saying we ought to be able to apply. The eligibility here is now there's so many people needing, clamoring, advocating for middle income or moderate income housing. How do we know that that logical assumption is defensible against any claim of, income bias? I support the logical assumption. I'm concerned about a litigation claim that we're pushing our values into this, as opposed to being neutral and just taking a more factual approach.
Well, we did have Brady look into this last year when we approved it, and Brady does think it's defensible, the disproportionately benefiting low income argument. And I know there were some concerns last year with affordable housing because sometimes with like the local city and county level work, their standard, their level of indigence for affordable housing, they follow HUD, so it might be higher than our 125. But there's some evidence out there, and again, it doesn't quite align to the 125 that it does just disproportionately help low income in our definition of 125. And so Brady felt like that was a strong enough argument and defensible.
Fine, satisfies me. Thank you.
Catherine?
Oh, you're on mute, Catherine. Oh,
I was going to say the same thing. I think there's adequate data on the housing one, particularly given kind of Section 8 and other requirements, to say that it does that. And even if the local standards are higher, it's still gonna benefit people that are at the lower economic end. So I think the approach is fine. So you beat me to it.
And this is definitely one category that we would like to have codified, just because you see there's so many activities that are done and it feels a bit, if we're all in belief of this, then to have programs think that it might even be questioned might not be helpful. Great. Okay. Great. Should we go into the next one? Okay. So our next category is education equity. These are activities that programs engage in that kind of to provide more resources or more advocacy for work that's in lower income districts. So we've been told that like it's very hard to get data that's at the 125% level because it just doesn't exist. So what a lot of programs that do work in educational equity, what they've given us is the free lunch standard, but that's a little bit higher than 125. It's 130%. And this commission has approved this over the years. We've used this back, we don't even know how far back. So there is a little bit of a reliance issue, but separately than that, we do think the 130 is a good proxy for 125. There's just not the data that exists there. So this is all brought to your attention every year. And again, this is a category that we hope to codify it in rules committee as well. Erica, do you have anything else further to add to that?
Yeah, seems to me like there's no evidence. So we've seen that everyone falls in the 125 to 130 category, right? Yeah.
Right.
Yeah.
Makes sense.
You could also just look at the dollar differential on income between 125 and 130%. How few dollars is that?
Yeah.
I mean, here again, it's the PR thing. Is it the cost of a Starbucks coffee? Is it that difference? Is it that small? So you can make ludicrous anybody who wants to say 130% is out of bounds. The cost of a Starbucks coffee, come on.
Do you view education equity as including educational issues for students with disabilities? Because I don't see that mentioned. And for the most part, it falls within the way we at DRC justified it was looking at the proportion of kids at free lunch on schools' campuses. And like in LA Unified, it's 80% of all the students or something like that. So I don't know whether it's possible to add that as an example, but it just struck me as missing from it.
We can definitely add that. And I'm trying to think, Erica, do you know we have an activity that came through?
Yeah, I mean, I'm sure that we do. So if you look at the number at the top of the slide, that's like every activity that, checked off its substantive area as being education related. So there were far more activities than what we're actually putting in this category. And the ones that are in this category or described as examples are the ones that didn't have quite the level of data that we thought would be required. I imagine if we had activities that were related to students with disabilities, that I guess in those instances, that organization was able to provide the necessary data. I understand what you're saying, that you used this type of data in the past, but perhaps whatever was provided this year was, more on point or was able to get other data sources. I'm not sure, but.
And Leah, let me just clarify. We're just, the totals here that are elevated to you are the ones that didn't have clear data. Yeah. So if a program, is engaging in educational equity work and they had like more clear data for us in whatever particular constituency, then we probably are not elevating it for you.
Yeah,
I'm not sure that particular.
Struck that education equity includes students with disabilities, and they should be mentioned as is somehow in that group. That's all.
No, we can definitely do that.
Yeah, that's my only comment.
Great. Are there any other comments? Okay, we can go to the next. And low-income immigrants is another one. And these are cases, a lot of them with DACA applicants. Erica, can you help me out some of the specifics of these cases?
I think, well, we may have separated them into a different category this year, but last year, a lot that were in this category were individuals who were detained in immigration detention.
Correct. That's what that's my experience from the work too.
Yeah. And yeah, or otherwise seeking, U visas had very large backlogs. So individuals were waiting years to get work authorization. So they couldn't find meaningful or gainful employment while they were waiting for their work authorization. Those are kind of the two main ones that are coming to mind. Yeah.
Are there any questions around this category? And it seemed pretty obvious to us that not only low income, but a lot of these type of cases, with unaccompanied minors, there's just probably no income. So it makes sense presumptively that it would be qualifying. Okay.
Concert break?
So low wage workers is another a category with some organizations to do a class action on behalf of low wage workers at a particular restaurant or low wage workers in a particular industry, but they haven't like sent out a survey, or they don't know kind of like exactly how many of those in that class are low income. But generally it would disproportionately, the argument is disproportionately help the lowest of the low income workers. And so we feel for that reason, this also should be a category that's qualifying.
But we've approved this. Sorry, can we go back to low wage workers just for a second? We've approved low wage workers in the past as well.
Mm-hmm. We have.
Okay.
Yeah, all of these categories it was the same categories last year.
Okay,
So.
just checking.
And the next category is work around public benefits work. So food stamps, SSI. And the category, the indigency category, is very close to 125, but it's not 125. But, we think and we believe that, with public benefits work, I mean, that work is naturally, to benefit low income communities and clients. So I think anytime there's a public benefits type matter, that should be qualifying. There's just not the data that exists. But like, for instance, SSI, depending on how they qualify, it's very close to that 125.
I mean, SSI is always going to be at 125 because the benefit levels are so ridiculously low. But I mean, I guess, are you folding within public benefits, Medicare or SSDI, which are at higher levels? So I guess it's just understanding
they are at higher level, but Catherine, I guess our understanding and our research is that they weren't much higher. I don't have the statistics in front of me, but that they were close enough.
Most clients who receive SSDI, which means they worked and they're taking a disability insurance benefit, can actually be quite high, because the people that get excluded from my former programs eligibility count are almost always people on SSDI, because you could get benefits that were several $1,000s a month or more.
So I think the way this is written is probably all public benefits. But Erica, do we have it? Do you know off the top of your head if we had a case that was SSDI?
No, not that I'm aware of. I think the ones that are listed here are the ones that were specifically involved. So, CalFresh, Medi-Cal, SSI, CalWorks.
So I think those make sense. I mean, even Medi-Cal now can go up to 300% of poverty level for some people. Like there's a specific category of children, I think, or it's 240 or something like that, but it's fine. I just really trying to be clear, like, are there things that are excluded? Like Medicare is something that covers people that have higher incomes, that are not seniors sometimes, and SSDI is different. So I mean,
so I think in the past we have been more broad in this category, but maybe we should think about limiting to just everything that's on this slide.
Yeah, and
And I think it's
Also-
poverty level programs, however the states defined it, right? So the state still considers essentially Medi-Cal to be a poverty program, even though there's ranges of what the percentage of, how high percentage of federal poverty level. But I don't think the state considers recipients of SSDI to be
Okay.
level programs, for example. So to the
Yeah.
extent that's helpful.
Well, because the way we phrase in the recommendation is including but not limited to, so it does open up for other categories. And I think we, like I said, I think we have read it more broadly, but we can just modify that and say including. Maybe take out the but not limited.
Can I comment on that SSDI piece?
Uh-huh.
I know Catherine's got a lot more probably legal background than I do. I have personal background, which, I mean, I know that I had a brother who was developmentally disabled and he was on derivative benefits from my dad,
Mhm.
which were clearly low income. You know, they were 900 or something a month. So I think it has a wide range of, you know, the amount of the benefits and the reason for them. I mean, the worker who's disabled, yeah, they can get a pretty big chunk of payment each month, but there's an awful lot of pieces to the SSDI as far as I know from that experience. So I'm just want to throw that out there. I think there would be a group of people who would qualify.
And this might be, I mean, the rules committee is taking up the definition of indigecy later this year. So I think this would probably be appropriate for the rules committee to kind of dig a little bit deeper and see the data and the research and really just look at all the income at that point for all these categories.
Yep, that's fine.
Yeah, I also think that, you know, when we're reviewing these activities, like, yes, we will see that they've noted it's a public benefits issue, but the organizations do have to provide an explanation for their reasoning about how it is primarily impacting indigent persons. And so, you know, it's not just, oh, it's public benefits that goes in this category. We do look more closely at what specifically they are working on, which type of benefit. So I find it unlikely, or, you know, a much lower likelihood that it would include those categories that may be primarily serving individuals who are above income.
Should we go to the next slide?
I mean, I
Erica?
actually like how you have it in the recommendation where it says means tested benefits. So that actually, I think, then addresses my concern, because if it's means tested, it's essentially means for kind of poverty level. So I think that's fine. I mean, I think you're fine with that.
Oh, this is the one that we separated, right? Erica, can you take this one? The youth and detention category.
Yeah, I mean, I think the rationale was for young people who are in detention that, you know, teenagers don't typically have income, or if they do, it's not a very large amount. And the added layer of being in detention could cut people off from other resources or access to resources like family members or their community. So we don't necessarily have income information for this population, but felt that it would be likely to be qualifying. And I think, as I mentioned, this note at the top about people in detention, most of those were in the low-income immigrants category of last year, because this is mostly dealing with individuals who are currently in immigration detention.
So
Really
I agree that most are, sorry, go ahead.
No, oh no, so I was just saying, so, you know, at least for the period that the person is detained, they would not have income. So.
Yeah, I think maybe it matters how we frame it. So I agree, I absolutely agree that disproportionately it is low income people, youth that end up in detention centers. But the fact that they don't have income, when the standard, I think, would require you to look at family, I think you should just be careful, because you don't want to be in a place that says we're disregarding family income, which is what you have to consider, I think, for minors, right? So I think it's fine to say people in detention centers, the data would support, are disproportionately low income among other underrepresented groups, but I I guess just be careful about what you say about it's because they don't have income, when youth should always consider their family income, I think.
I also have a question. What kind of civil litigation are they doing for youth in detention?
So it could be, like, some of these are juvenile facility, like
Yeah.
juvenile facilities. They're not, they're not like a kid prison. They're like a youth detention center, which is not, I don't think a criminal confinement, but in addition, I think you can do work relative to the conditions there. So like a DRC used to do, like, kids in detention do not get access to public education, which violates their special education rights because they're still entitled to an education while they're detained. Or there might be other lack of treatment that's provided. So people have mental health issues, but the facility doesn't provide mental health treatment in any meaningful way, which the state would be obligated, to, the state or the county would be obligated to do.
I have a question. As I'm looking at this, I'm thinking of all the various detentions for youth. So there's immigration detention, there's dependency detention, there's criminal youth detention. And there are all these buckets, and I'm not sure that they would all be treated the same. I mean, a youth in detention for a crime, I mean, sadly, it may not work because it's a crime. If they're in foster care detention in a group home or something, that's a whole different, and you know, and their families may or may not have money.
Yeah.
But I think we need to look at the definitions for the different kinds of youth in detention.
Yeah, I agree with that. And again, sorry to say this again, but maybe the rules committee could take a closer look at that, because the two activities under here are, those are the facts. They describe the two cases.
But this is recommending that all youth in detention, at least for this year, be approved as qualified for IOLTA eligibility, right?
I think the way you're reading, Erica, if you can correct me if I'm wrong, but the only two that are under review, there are only two under review. The other ones have submitted enough documentation to be sufficient.
Yeah.
So in other words, there's one case involving the reconstruction of the facility, and there's one case about children immigration detention, and those two didn't provide sufficient data. So we should assume, the request is that we assume that the recipients of those things are.
Yeah. So the other option, what we probably should have done, because there's only two in this, we could have pulled them out as individual cases, but we grouped them.
Okay. Pamela, you have a question?
For what fiscal year is this activity for?
So this is for year ending 2020. So any activity for the 2020 calendar year.
So thanks for clarifying, Dawn. That was actually helpful. I somehow thought this was, I don't know, I was getting rules committee mixed up with, this is just about reports that have these specific examples in them.
Yeah, these are just these reports, and this is like a stopgap measure because we don't have a codified policy, and that's why we're elevating it to you, because there's not a formal policy. And so again, staff as well as the commission is not, so we have to elevate it to you.
Okay.
And again, that's why it's a little tedious, because we do go through, I mean, we've spent nearly 2 months reviewing it. And Catherine, I don't know if you remember on the program side, it's a lot of work for programs to do each of these activities, these reports too.
I just viewed it as like, we get a lot of money and that's our responsibility to justify it. So I was never bitter about it.
Oh, okay, that's great. We've heard otherwise from some programs. We feel them.
I feel like, I don't know, you get a lot of money, you should have to explain it. I guess I just want to say something in response to Louise, because it comes up in this example, which is there is a prohibition against doing something in that's criminal, which is generally, I think, in a criminal proceeding. But these youth have now been detained in a facility. It's not a criminal proceeding. You're actually bringing a civil action to address the conditions that are in the facility, which is why I think it's appropriate to still, even though it is a secure juvenile facility and they're there as a result of a criminal charge, you're not engaging in a criminal representation because the actions brought in civil court.
Yeah, and that's how the commission has taken that stance too. That's why we allow like habeas petitions, and it's, you know, sometimes it's about the confinement versus the underlying criminal.
Not the underlying criminal charge, you're not addressing the underlying criminal charge. And these are really some of the youth that are most in need of assistance. They get overlooked easily. So I think it's great.
Is there any way, can we also say that like the evidence that was submitted for the 14 that you're not concerned about, can that also support our view that the youth in detention is primarily indigent? Does that make sense?
I can't recall now off the top of my head those specific 14, so I can't.
Okay.
I can't say that right now, but maybe Erica, can you?
Not a big deal. I'm just trying to.
I understand your point that, you know, if there's this many other activities kind of along the same lines that did provide the necessary data to demonstrate that they're qualifying, I think, I think it makes sense. I just, without knowing off the top of my head how many of them are closely related to these particular activities, I'm not sure.
Got it. Okay. Any other questions or concerns? Okay. Do we have another bucket?
No, that's it. So I don't know in what order the committee wants to address these, if you want to go through all the activities that the committee is reviewing today, or if you want to.
I think it might, my suggestion, if Erica and Dawn, you are agreeable, is that we resolve this one and then move on to the specifics, just because I think this will provide you guys with the guidance that you need on a whole batch of them. Any other comments or questions or concerns from the committee on any of these 6 buckets?
No, would you feel comfortable voting one motion for all 6? Is how we have it presented?
Yeah, that's a good point.
You want to I mean, the motion seems like it's structured for all 6, and I'd be happy to make the motion as it's reflected on the slide.
Yeah, and just quickly, does anybody have any concerns, like they think we should not approve any of these, that we'd want to pull it out as a separate motion? So I don't want to lose votes if people are like, oh,
I think Bob's point was that earlier that we needed a motion and a second before any discussion, but I don't know whether you want to be that formal or not. So that's why I made a motion.
Thank you.
I'll second, just in case we need one.
Thank you.
Erica, roll call then, right? Is it roll call now, or sorry?
Sorry, I just want to make sure though, no one has concerns about pulling any of these out, right? I hear none. Okay, great. I just wanted to make sure I don't want to lose anyone saying no because they have concerns about one. Great. Well, it sounds like we have a motion and a second.
Yeah. Take roll call. Connolly?
Yes.
Foggy? Master?
Yes.
Bennett?
Abstain?
DeBose?
Yes.
Delfino?
Yes.
Friedman? Mann? Meeker?
Yes.
Mantle?
Yes.
Savage?
Yes.
And am I not on this committee, right? Is that why you're not calling my name? Because I know it happened with the minutes and I thought, well, I don't know, but you asked about it. So.
Oh, sorry about that. Yeah, Erica, is Catherine not on the roster?
I have her on the vote tally, but I guess sorry, I have her on the roster, but the vote tally sheet was not updated. So I'm sorry, Catherine.
No problem. I'm voting for it. I thought maybe I'm just here because I'm supposed to be observing and then I'm taking up a lot of your time with
No, you're definitely on the committee. Sorry about that.
Yeah, you are. That was
okay. Perfect.
I have Catherine's vote as well. Sorry about that. Yeah, the motion passes.
This is Bob. I wanted to butt in before we go on. Regarding my concerns about process, there is a way we could do something akin to a consent calendar approach where at a public body, these items are on the consent. Does anybody have any objections to the consent? Do you want to pull something off? We could take that approach without saying, I want to talk about X or Y or Z, or I don't like X or Y or Z. But, you know, prior to a formal motion, we could say, does anybody want to pull any one topic or any one agency from the bucket list here? If so, then we'll segment that off and then go for a general motion. The consent calendar approach saves a lot of time. And if need be, I can talk to the rules committee if whoever here is on that wants to pursue that approach. Thank you.
Thanks, Bob. I feel like I need to study up on my parliamentary procedural rules, so I'll try and do that before the next one. I assumed because we were having other discussion, we could just have our discussion, but
It's
I
also a
apologize.
governmental approach. It's not always parliamentary procedure. Sometimes you've got to go look at California state government procedure on consent calendar too.
Okay. I'll see if I can find like a guide. Thank you for the
I
keeping
think
it.
we follow, I think Brady said we follow Robert's rule, even though we're not like subject to it. So I can send you a link, Erica. I mean, we can study it together.
Great, thank you.
But again, Robert's rule doesn't always fully address this as a consent calendar. Robert's rules was primarily started for private groups, believe it or not. It was not meant for the English Parliament. That's a misunderstanding. So therefore, what isn't in parliamentary procedure is still in governmental procedure. That's why I say you have to go to Cal State Legislature for also the information you need about this.
Okay.
So we can check, but I'll check with Brady. But I think my understanding is we're not subject to everything because we're quasi-government, but we'll double check.
Okay, so good discussion on these.
Okay.
Okay, so we have, do people mind if we take a quick 5-minute break? I need a quick restroom break. If that's
Please,
okay.
yes, yes.
Okay. Let's do 5 minutes and then we'll be back. Thank you. Trying to make it through 2 hours, but it wasn't gonna happen.
So just to be picky, if you say recess, then you don't have to worry about possibly another quorum call issue.
Okay. I'll try to do that next time. I really need to study up on these, Bob. You're keeping
I
me.
had to run, look, I had to run the ethics commission and had to make sure we were litigation proof because of all the an expletive deleted in San Francisco. We actually had somebody appeal one of our decisions to the Cal State Supreme Court, and the Supreme Court upheld us. So
Okay.
I feel good about how I ran the commission and
Yeah,
our decision process.
no, it's a really good point. I just need to study up on it. But speaking of which, should we try to do
Yeah.
roll call just to make sure we have everybody back?
Okay. Connolly,
Here.
McCloskey, Master,
Here.
Bennett,
Here.
Blakemore,
Here.
DeBose,
Here.
Delfino,
Here.
Friedman, Mann, Meeker,
Here.
Plantold,
Here.
Savage.
Here.
Great. Yeah, quorum.
Great.
Okay, so bring back up the PowerPoint. Okay. So I think where we left off was kind of going over those broader categories under which several activities fell. Now the rest of the presentation will deal with the individual activities that were noted and elevated for review in the memo that was provided to the committee. So there were, I believe in the memo, 10 activities. Since the memo went out, 2 of them staff has reviewed again and found that they are qualifying. We did another pass on those. So we'll only be going over 8 today. But the first one was Disability Rights Legal Center's cancer policy advocacy. This was advocacy work related to increasing benefits for individuals who may be ill, and their justification in the population that is benefited by this work. They said after deducting, for medical expenses, the individuals who would mostly be benefited would be considered indigent under the statute. So it was based on their previous work experience, as my understanding. They didn't have a data set necessarily, just that in their experience that the individuals who would be benefited most by the type of advocacy they were engaging in would be considered indigent. So it was elevated for that reason, that there wasn't actual data reported out in terms of numbers or percentages. But the general leaning from staff was to approve the activity.
So was this to add a benefit? I mean, I feel like I don't quite understand what this was, to add a benefit to covered California. I'm not sure I'm understanding what the activity was.
Yeah, there wasn't a ton of detail in the report itself. I can pull it up briefly. 1 second.
I mean, if we got these in advance and I missed them, I apologize.
Yeah, they were attached to the memo at the end, but there were. It says
At the end of a 96-page memo. That's why it was difficult to scroll through and
I
find.
actually thought it was the rest were statutory things, so I admittedly did not get that far.
It said that the outcomes or the goal of the work was supporting programs that would lead to improved conditions for low-income Californians that have been diagnosed with cancer. The overall goals of our advocacy efforts are to ensure that those who are indigent and have been diagnosed with cancer or affected by some other chronic illness which qualifies as a federal disability have the best preventative care and access to appropriately manage their diagnosis. And so the specific activities that were listed were to provide treatment availability, paid leave, or access to insurance and coverage that these individuals otherwise would not have had.
So was this individual advocacy then? I don't know.
It was supporting bills that.
But they don't say what bills or anything, I gather.
Covered California Affordability Support, Lymphedema Treatment Act, and Paid Leave Act.
I'll also note Pamela just put some questions into the chat. Pamela, do you want to ask them directly, or do you want me to?
There is that the data that was just presented is not what I saw on paper. So that I was trying to filter out what they were claiming to do work on behalf of their community. I don't see I don't see what they have on paper in their reports adding up to what was just presented, which is a whole different category, cancer policy advocacy. And I also kind of looked at the letter that we received in February to kind of gauge what I'm seeing here on paper versus what the point of the funding is for. And I'm just not seeing their responses adding up to, like, again, this one here, cancer policy advocacy. That's a whole different response than what I see here. So I don't see anything connecting.
Pamela, I think your questions, were you saying that Disability Rights Group was working on the like UC Regents case? Is that
Right, everything, yeah, I read all of the programs that were submitted for us to consider. I read through what their data was, what they, so that name, disability rights,
There, sorry, I don't mean to cut you off, but there's two organizations there's Disability Rights Education and Defense Fund, and then there's Disability Rights Legal Center. So
okay, so I
maybe that's the
So
the difference here.
Yeah, page 74 in the memo provides Disability Rights Legal Center's cancer policy advocacy.
Right, I pulled that out separately to read it very carefully. So I see the Disability Rights Education Fund.
So Pamela, you're just gonna let Bob has his question, then we can circle back. Bob,
Okay, go ahead, I'm good.
Okay.
I wanted to bring to your attention also, separate from ADA, the UNRRA Civil Rights Act, which is back from 1968, is also and has been often used by people with some disability claims. So keep in mind, even if this agency didn't mention UNRRA, it may be relevant, helpful for our staff to look at the uses of UNRRA civil rights on disability claims.
Yeah, that's a good point. I think, but this one, they're specifically looking to support bills that help with the treatment and access and paid leave for cancer survivors or people who are dealing with a cancer diagnosis.
My concern was to address Pam's thoughts about ADA. I wanted to make sure we knew there's more than ADA that's potentially a concern or applicable, not in this case, but broadly when it comes to disability responsiveness.
Fair point. Pamela, were you able to find the cancer policy part of the memo?
I'm looking at it right now.
Okay.
I didn't, this one, I didn't, I think I limited myself to maybe 7 concerns. So, but this one, I did not see it all. I skipped,
no, that's fine. I just want to make sure.
I saw everybody else, yeah. I'm looking at it, but, so my question was for their the
Disability Rights
Education Fund.
Yeah.
So,
okay,
yeah.
we'll hold, I'll make sure we get back to your questions on the disability rights education. So on this and the cancer policy, do we have other comments or thoughts on this?
So it's Catherine. I guess I have 2 thoughts. So I probably agree that most people with cancer will meet an indigency standard at some point because of challenges of working and medical cost, etc. I actually find it very difficult from this to understand what the work is they did, something called cancer policy, whatever work. I mean, I thought as I recollect the forms, wasn't there like some more generally more detailed description of what the work was? Like, I don't actually understand what they did. So for like that, just maybe my lack of understanding, but anyway.
Yeah, my understanding is that they supported these bills. I don't know necessarily to what extent they were involved in terms of if it was.
That's okay. I just like on the form that we have in the thing, I don't know.
It says activities, but it doesn't say what they did. It doesn't describe an activity. It only quotes, I guess, a piece of legislation. So I think, well, that's my difficulty.
Right.
in understanding it.
It doesn't, it seems almost like they should describe in more detail what it is they did, what the bill was designed to do, something that, I don't know. I mean, I
Yeah.
probably, they're indigent. I just don't know. I just don't understand what the work is they did.
And I think if the committee wants more information and doesn't feel that this report is comprehensive enough to make that determination, that is an example of, an instance where we can go back to the organization and ask them to supplement if on its face it's not sufficient for committee members to feel comfortable making a decision.
Yeah, we're happy to do that. And also just as practice, if we do elevate an activity, we have instructed staff that has worked on this to go back and give programs an opportunity to supplement or add to it. So I'm not sure that's done. That's kind of the staff instruction. So we can certainly go back again if you feel like you need more information to make a determination.
I mean, I think it would be really helpful to have the actual legislation to look at and see, try to interpret it or have.
Well, and what they did, I mean, they're identifying this as one of their significant activities.
Yeah.
Right? And I don't even I don't understand what the policy issue was entirely,
Yeah.
but I also don't understand if this is a significant activity, what they did in the activity.
Yeah.
So kind of both of those for me.
So why don't we just pull this? We won't vote on it, and then we will get more information for the next meeting.
Yeah.
Okay.
I will also say, I don't know this like population as well. So I have a few more questions on the indigency element. And so to the extent that the legislation can like show that it may be like primarily like particularly affecting people who have indigency concerns, like with paid leave or with access to insurance, just something else for them to think about on the information gathering.
I mean, if it's covered California, they should be able to tell us. I mean, there's data about what percentage, what are the levels in covered California and what I think percentage of people fall within each of those levels. So it's something that's fine. We can find out about.
Okay.
Yeah, just I'm saying in the information gathering, that would be.
Before we move on.
Yeah.
Before we move on, I wanted to raise a grammar picky point about staff.
Bob,
you froze, Bob.
Can you? Bob, I don't know if you can hear us, but
Yeah, he has to restate.
Individuals who would receive benefits. And that may be the case in other situations. It's, that's impersonal. And we're dealing with people. Most individuals who would receive benefits is the way it should be drafted, please.
I think that's a direct quote.
Bob, you cut out, so I like missed the first half of what you said.
So I'm going on what staff had written and not about the content of the response of the agency. In the PowerPoint slide, on the left column, there's blue headings, the one that's Nexus. If you read across from Nexus, most individuals that would receive benefits.
Bob, that's a direct quote from the, we didn't modify it. That's from the applicant submitted the program.
Wow. Okay. I thought that was your analysis. I'm sorry. Well, grammar points off for them. Okay.
Okay.
So I think we're clear about this one, right?
Yeah, let's pull this one.
Let's pull it and we'll get more information for you.
Thank you.
I'm sorry, can I just ask one question? Did Disability Rights Legal Center indicate that they had no data on the breakdown of individuals receiving benefits? I mean, we're looking at indigency. I have a hard time believing that information is not available. I mean, this is one of the key things about pushing the Affordable Care Act and Covered California, our version of it, which is how many really poor people are served. So I'm only saying that because they have an obligation to present the best case they can.
Oh,
Yeah, so Kim, your point was exactly mine. You just said it better, which is Covered California covers indigent people and it is a knowable number.
Yeah.
What percentage, if this work was in fact about Covered California, which I don't entirely know for sure.
Yeah.
But it is a knowable number that they should be able to provide the percentage of people that are indigent
Right.
or eligible for Medi-Cal kind of under it.
Right. Those numbers are available. So,
Correct.
Okay,
Yeah.
we'll ask that direct question.
yeah. Thank you.
So the next activity was National Immigration Law Center's.
So the next one in our packet was the
Louise had
Oakland
her
one.
hand raised.
I'm sorry.
No, I'm sorry.
Did the Oakland one get pulled, the Oakland school one, which was, I thought, the next one in the packet at least?
The packet seems alphabetical, right, Erica? But we were pulling it. We should have ordered it so it follows this. So we
Can
apologize.
you just reference page numbers to where you're starting each section?
Yeah,
That way
so
we'll
that I
know.
can look at it since I missed this whole.
Yeah, just start off with page number so-and-so, then we'll just go directly to that.
Can I go back to the other one?
It's on it's on 83, it looks like.
Okay, sorry, Louise has a comment on the past one.
So Catherine had mentioned, I think it was Catherine, that the Covered California is mostly low-income people. I mean, that's not my experience at all. I mean, if people don't have, partly because I do divorce law, my private work, people who have, I have clients who have, you know, really large spousal support and property division, and they have no insurance, and they can get on Covered California. So,
And Louise, I think I was not clear. I was just saying the number of indigent people on Covered California is a knowable percentage of
yes,
people. that would be
yeah,
eligible.
absolutely. Okay.
So I wasn't trying to say that it's most people. It's just there are people that are indigent who get free Covered California and don't pay a subsidy, and that number is knowable. You get
Yes,
subsidies up to 400% of poverty level, I believe.
yeah, you're right. And so thanks.
Yeah, thank you. Thanks for asking.
Okay. So next one is PK versus Pompeo, and I have the page number. It's page 83 in the memo. Oh, sorry. Did somebody already say that? Sorry.
It's okay.
I thought I was being so clever with my control F.
Okay, here we go.
Anyway, Erica or Dawn, do you want to?
Yeah. So generally with support centers engaging in impact litigation work, for a support center to be able to provide direct services, they either need to be co-counseling with a QLSP or providing the service at the request of a QLSP that's unable to do so, or working with a pro bono, providing services to indigent persons. That's what the eligibility guidelines outline. For organizations, for support centers that provide services out of state, we say that they can't use that for the significant level test, meaning, you know, they need to meet one test showing that they're providing services to QLSPs in California. But for qualified expenditures, they can provide similar support services elsewhere, and that can be counted for the purposes of primary purpose. So this was one of those activities that it's provided out of state. So clearly there's no QLSP partner, but it was unclear whether they were partnering with an organization that would be providing similar services as if they were doing co-counseling in California. So that was a little bit of it's a little bit technical, but because they were partnering with Jenner and Block and I think the ACLU. So yeah, they aren't required, you know, that the plaintiff has to be indigent, but generally speaking, if they're partnering with a QLSP, the plaintiff would be indigent, but they're not required to income screen. So I think this is just kind of a unique situation that we weren't sure which way to go on that, because it's not partnered with a QLSP, but perhaps it satisfies the requirement to be
Did
counted.
you ask them for information about the indigency of the individuals that are represented?
Yeah, they don't know because it's based on diversity visas, and that's not an income-based constituency. So,
and this is an ongoing activity, a case. So last year, we were about to elevate it to the committee, and then they decided that they they decided that it was not qualifying. Now this year though, they're trying to qualify it. So
Well, then, if they conceded it wasn't
yeah.
qualifying, then how have they explained why it's changed then?
I think that I don't know if the description is different necessarily. I think it was that they didn't necessarily want to get into it last year, and so deducted it perhaps for convenience. But so we never actually reached the question of whether this would be an activity that's qualifying or not. They kind of self-selected themselves out of that process.
But the standard is that you have to be able to show that it impacts people who are indigent. And for support centers, you can demonstrate that in some alternative ways, which is you're partnering with a qualified organization, for example. So I guess they have to be able to explain the benefit to indigent people. I can wrap my head around how it benefits Californians, because I presume it might be it's a policy issue that's going to affect the country, but I still seems like they have to explain to us the indigency in some way, either using the support center standards or using just some other way to demonstrate indigency.
Well, this is where it's a little bit tricky for support centers, because there really isn't a requirement explicitly about that it has to benefit generally even indigent clients. And so it's a little squishy, and this is why we're elevating for you. If you go back, Erica, why don't you go back to the definition of the primary purpose for sports centers, and you can look at that a little bit.
I guess, but when a qualified legal services program is doing the work with you, qualified legal services can only do work on behalf of indigents if it's going to be qualified. So that's sort of a way that you bootstrap the indigency that the underlying qualified legal services program found. Right?
Can you go back one screen? Sorry, thank you.
So the statute, you see how for primary purpose, it's these support activities, legal training, legal technical advocacy without charge. It doesn't really talk about indigency. Then if you go to the next slide, that's where we define in our guidelines what a support service is. And in there's some talk about indigency, but this has always been very confusing for both staff and programs where the line is. So yeah, obviously if they're co-counseling with one of our QSPs, it's a no-brainer, right? It's in this instance where we're not really sure if they're then required to demonstrate indigency. I think that's where the crux of it is. And so that's where we're elevating it to.
Why would they not be able to? Well, why would they not be required to, is what I meant to say. It strikes me as that would be a really unfortunate loophole. I mean, there's got to be some connection to serving an indigent population. Otherwise, it seems just counter to the statute and the whole purpose.
So Erica, if you go to the next slide where it has the definition in our guidelines. So this is what we define in our guidelines as support service.
That's the state bar rules.
Yeah, state bar rules.
So don't they have to demonstrate one of the three of those under the rules then? So they don't meet number one, I believe.
They don't meet number one. So I think it has to be under, they're not
the direct provision of legal services to an indigent client of a qualified legal services project. So they can't meet number two, right? They're not meeting number two?
Right.
Well, there's an A and B.
Okay, they're not meeting two. So it's very little on my scroll down.
Well, but you still need the indigent client, whether it's A or B. and
Well,
they gotta turn
that's
out.
what I'm saying. They need to come up with something.
Yeah, I guess I feel like I do not have enough information to say that this is an eligible thing because they need to explain under the state bar rule of B, 1 and 2A or B, how they meet that criteria.
Correct.
Right. I agree.
I think the difficulty is that in our eligibility guidelines, there is language to the effect of, you know, as I said, similar work performed out of state, similar services provided can be counted for primary purpose. And so we don't have QLSPs out of state because QLSPs are, you know, specific to IELTA funded organizations, but whether other nonprofits that provide services to indigent persons would count. I think that's where.
So,
But we're still dealing with indigent.
Right.
Yeah.
so who are they
Debate.
working with out of state then?
General block, ACLU.
Mhm, ACLU and general block.
ACLU does not just serve indigent people. So if they were working with a
Well-
legal aid program out of state, I think that might answer the question.
But that data is not provided.
Right. I guess maybe Erica, I think it seems like what the committee is saying is in order to be similar out of state, it has to be parallel to these things, something that would require, and that requires an indigent client. And since they haven't established they have an indigent client.
Yeah, but that's the piece where, because we don't have a exact site for the indigency, you feel comfortable.
Well, to be fair, like do our guidelines comply with the rules then? Allowing out of state? That's part of,
California should be California based, period.
yeah. Does that make sense?
We've allowed out of state work as long as there's some nexus to like helping Californians.
Yeah, I'm not troubled about the
Yeah.
out-of-state work. So I agree it would impact Californians in this category. That's not a question. It's really to say you have to demonstrate that you are providing the services envisioned by the rule, or I guess the eligibility guidelines. And I don't see how they meet the standards of the rule because I don't have any information that says that. And I guess for the eligibility guideline, then they're working with the ACL. I don't know. I
Do
don't
you have the eligibility guideline? Can we look at that
Yeah.
language?
I don't know if it's in the PowerPoint now.
Is it in our memo? The only reason I'm saying that is the
Yeah.
eligibility guideline may provide us some of the wording. Here, it's in our memo. Page 44 is where it starts. Do you know which guideline it is?
I think it was 2.2.1 maybe.
It's 2.2.1
No, that's the significant level test.
or 3.682.
It's the significant level is the QSP. It's the primary purpose prong,
Yeah.
Erica, I believe, because primary purpose we allow them
Yeah.
to out of state.
So which rule is it? I'm sorry, what number is it or what page is it?
Page 4 of their memo.
Page 04 of
Or
the
of their memo.
It's
Oh, no,
2.
I wanted to look at the
2.3.
eligibility guideline.
Yeah.
It's 2.3. Sorry.
2.3.
Thank you, thanks.
2.3, is that what you said, Erica?
Yeah.
Primary purpose.
Can you put that up so we can see it without having to dig through the other document?
Yeah. It is page 52 of the memo in case you want that reference.
Oh, 52.
Okay, you may consider the provision of similar services in other states when determining the primary purpose and function of the corporation.
So what is their primary purpose state?
The provision of similar legal support services in states other than California, which goes back to the fine. Then we have the definitions in the rules, which say it's someone providing legal services to people who are indigent, right?
Yeah,
So I still am not understanding.
I
that.
think we're making this more complicated than we need to. They have not
Right, that's what I said.
demonstrated in any way. I kind of interrupted you, Catherine. I'm sorry,
No,
but they have
no.
not demonstrated in any way that they are doing work that provides a benefit to an indigent population and that they are representing
So,
indigent clients. And I think that's what we need from them.
so that's the piece that we actually haven't required programs to say that. Are you saying that that's how you read the commentary? That there needs to be that they demonstrate that they have to help indigent clients? Because we haven't required support centers to do that in the past.
Well, in most cases, it's clear because the support centers in California are working for the QLSPs. We've just got this sort of odd situation where they've got, where they do in this instance, I think, do need to establish it. It's kind of automatically established when a support center in California says they're working with a particular QLSP. I mean, it's not 100% that way, but I think that they can easily demonstrate it.
I just think
there's something missing here.
Work, they have to show how the work, so it says, or doing work out of state for like a similar organization, right? So fine, then go back to the definition in the state bar rules that say it's supporting these kinds of activities, and there's two different choices. How is it doing that? And I mean, maybe let them tell us how the working with the ACLU is the same as working for a qualified legal services support center. I don't think, I appreciate you haven't gotten into the indigency with them, so I'm just approaching it differently of show us how the work you're doing with the ACLU in some other state is the same as doing the work that's in the rules, because that's what the guidelines say.
okay. Herman, you have your hand raised.
Yes, Don, did I understand you to say you haven't been asking people for this in the past?
We haven't with other support centers, and that's why I'm not saying maybe your reading is not correct, but that, and at least we haven't done that with other support centers.
So would
There's also not-
would we be changing the requests or the standards for others? I think if we're going to make this change, should we do that for everybody? Or should we, in the next iteration, bring this point out? I think we would be doing ourselves a disservice if all of a sudden we say we're changing the rules.
I don't think we're changing the rules. I agree we shouldn't change the rules, and I agree with Dwan. If we haven't asked other people to show how the clients are indigent, that we shouldn't do that, and that's not the standard. I'm simply saying the standard is you have to show how, if you're doing work out of state, how the organization is similar to what's actually in the codified rules about supporting these organizations. And I don't think they've done that. They just said, oh, we're working with the ACLU, as if that answers the question.
Yeah.
But have we asked people to do that before? I agree with you, but I think we should include that in the next iteration. But to go back, would that mean staff has to go back and read everything again to see if everybody meets that standard?
No, I think how Catherine just phrased it is a fine distinction. So we haven't required programs of the indigency, but I think it's fair game to say, ask them, how do they demonstrate this according to commentary in 2.3 to be similar to, though we haven't done it, that's not how we usually.
Does that mean that you would go back? Does that mean you go back and look at all of the documents and see if everybody does that?
No, because we would have pulled it out for your attention now, and that none of the other ones triggered the same way that this one has.
Just as long as we're treating everybody the same, that we aren't creating new things that we haven't asked for before, but now all of a sudden we're asking for them now. I think that would be a disservice.
I agree with you, and my understanding is that this is the only one that raises this unique circumstance, and my guess is that the other ones were all doing work with qualified legal services programs in California, so it doesn't raise the same issue.
But I think you raised the issue, I guess, but we don't actually know.
Dwan said she knows.
No, yeah, or else we would have elevated it for
Yeah.
you the same way we did those other, and then that's why I'm saying that it's a fine distinction in that we have a required program support centers to demonstrate indigency, because our reading is that they're not required to, but we haven't looked at it in the context of out of state, and we would have elevated at the same time, because that's why we're elevating this case.
Okay, let's let Jim and then Kim have their hands raised.
Yeah, maybe I missed a point. I saw this organization primarily working against the Trump Muslim ban. And so is it logical to assume most of the people that were impacted by the Muslim ban are indigent?
No.
That doesn't seem to follow to me.
I agree with that. It doesn't follow.
I agree.
Kim, did you have a comment?
I think I kind of want to correct myself on something I said earlier about, the assumption that if it's working with the QLSP, I think typically when we've looked at these, the descriptions of in addition to the support center working with QLSPs in California, their descriptions of their project have presented the indigency. And so although it's not completely safe to just say, oh, well, they're working with the QLSP, so of course there's eligibility there for the project. It's that there's typically a description that supports who they are serving and satisfying the statute. And I'm gathering in this instance, we don't have it and we need to go back and get something.
Yeah, I think that's right. I mean, there's like Erica is saying, a technical question, but like the substance of it is what gives us pause as well. So it's the two, yeah.
Yeah.
Okay, so just to make sure, because it sounds like what staff needs is like a site, right? So the standard, I guess we are saying, is that in the eligibility guidelines, it refers to out-of-state similar legal support services. I assume the committee is in somewhat agreement that refers back to the legal support services definition in the rules. That requires that they either be providing professional services to QLSPs, ergo it would have to be professional services to something equivalent to a QLSP out of state, or they are providing direct legal services to an indigent client, blah, blah, like related to a similar QLSP. Is that kind of what is that what staff has generally interpreted?
What you said is what I've my understanding from the conversation.
Okay, so you could in theory go through the first one without having an indigent client, because QLSPs do non-indigent clients occasionally too. So what they need to do is either show it's an indigent client, or that ACLU / they have another one, Arab American.
Jenner Block, I think, it's a law
Jenner
firm.
Block, but there's a third advocacy group on there.
Yes, it was a discrimination.
Right. So they have to establish that one ACLU or the other one are either the equivalent to a QLSP, or that they're helping an indigent client. Does that make sense?
Yeah.
Is everybody kind of on the same page? And I don't think that's not an extra requirement to Herman's concern, based on what you guys have done in the past, right?
No, that's not an extra requirement. I mean, we would be pretty much saying, show us how you adhere to this piece of our guideline and state bar rule.
Got it. And so at this point, we could reject them, but we're, I think, going to try to give them an opportunity to provide that information. Is that sort of where the group is? Are we okay with kind of tabling another one and taking a vote on it?
Yeah.
Okay. Does anyone have concerns with doing that? Okay. And staff, you're not going to have to go back and start looking at other support centers or anything like that. If we do. Okay.
I think NILC is the only organization I recall that does any amount of regular amount of work outside of the state like this. I think, yeah, as Dwan said, we would have flagged it if there were others along those lines, and this is the only organization I recall fitting into that category.
Well, so now that we've provided the guidance, hopefully they can come back with the information, or maybe if they decide they don't want to go through that, they can determine whether they want to go through explaining that.
Okay.
Okay, and hopefully that provides guidance for you guys if this comes up again. Ugh.
And
Thank
yeah,
you
these
for
are
the
why these are
lively
individual.
discussion, everybody.
No, these are hard, these individual cases. Okay.
Why don't we do one more and then let's take a little break for lunch?
Okay.
Because it's after 12.
Okay.
So this guy's on page.
Yeah, let me see. Let me transit. That's on 92, transit
92.
equity advocacy.
So yeah, so the next activity is from Public Advocates, their transit equity advocacy. This is actually an activity that's been approved in the past. One of the reasons it was elevated is that the activities have slightly changed, but they do provide a good amount of data to indicate that, you know, the population that's disproportionately impacted are indigent persons, but it wasn't, you know, conclusive. So that's really the main reason it was being elevated, because it could possibly affect larger groups or even all Californians when it's related to transit funding. But on the whole, we felt that it is qualifying, but like I said, because of the data not being conclusive, that's why it was elevated.
So it's Catherine, and I liked their explanation on
Mhm.
94, page 94, about the indigency of individuals, which is among those who rely on public transportation to work in California, some number have less than 150% of poverty level. A majority are less than 100% or less of poverty. And people are twice as likely to be living in poverty as compared to others. I mean, those seem like
Yeah,
pretty good.
I think we may have, because it was a long explanation, we took excerpts out of the report. I think that explanation was focused solely on essential workers or frontline workers. I forget the exact description. And so, again, I think it was just a question of if you want to focus on a narrower subset of commuters or individuals who primarily use transit, then in that instance, yes, they did meet the threshold. Whether, you know, of all transit users
This
was
was referring to the US Census data, that public transportation riders are twice as likely to be living in poverty.
Right. And again, in that example, it says twice as likely to be living in poverty, but the number itself, what cutoff is used, I wasn't sure. But I don't think we have any major concerns on the staff side.
This is Bob. I need to butt in. I've been a part of this advocacy campaign, so I need to recuse myself from all of this discussion and vote. If you're going to go break for lunch, when should I tune back in? I'm going to stop now, but when should I come back on when your lunch break is over? Give me a time estimate, please.
I know somewhere between 12:30 and 12:45, but we can also email you.
Okay, email, good. Thank you.
Sure. What was I going to say? I had other thoughts or comments, concerns about this. So just to make sure I understand, staff's concern is transit advocacy kind of helps everybody. Public advocates has said, but really most people who use transit are more likely to be indigent, and it'll more positively affect them, right? Because they don't have alternative means often to do transportation. So
Yeah.
whereas higher income individuals can use their car if something happens. For people who are, you know, are indigent, this may be their only means.
Exactly. Yeah.
Okay. Any other thoughts or
I
concerns?
guess that you said that this had been approved before, so what made you, so it was approved before, you found it to be, you know, something that benefited people with indigency. But what changed this year? So I guess I just want to understand what changed this year that made you question it, because maybe it's important to know that.
I don't recall off the top of my head. I think it was just, it's a lot of these activities, you know, kind of evolve over time. I wasn't really the activity itself though that was concerning. It was just the data, and they didn't necessarily fit into like one of those other categories where we had multiple activities kind of fitting into a bucket. So
Thanks, Eric.
I do think it's interesting that, although I think what they're putting forth as, you know, having a disproportionately favorable impact on poor people, I'm kind of surprised they didn't have a different data source other than the census. You would think that there would be something produced by the state and also various transit entities, you know, to give you more detail. But I mean, I'm persuaded by this, but
Yeah, I mean, the staff recommendation is to approve this, and this is an organization
oh yeah, they're
you know, they've really struggled providing this data, and so they've actually had to hire like a consultant to help them with this. And so it's kind of unfortunate that they have to spend money in order to respond to. So, and they've come to the Rules Committee meeting and have provided some really helpful comments on how maybe perhaps we can modify our standards to be a bit more flexible for programs.
Okay. Do you want us to do the vote at the end? Okay, but in general, are people feeling like they want to approve this? Any concerns?
Yeah, the vote would be per item, not as a collection. My comment.
Okay, but we can do it at the end. We can sort of break them out if you'd like. If there's ones that you have concerns about, Pamela. By the way, you had questions on the last one. Do you want to make sure that, do you want to have the staff get the answers to those?
Yeah, exactly. As long as the data, as long as my questions are here, you can, you're feel free to manage it and put and send it to them and let them respond back to you.
Yeah. So staff, I don't know if you saw Dawn and Erica, Pamela's questions, but maybe other information to inquire with the organization, the last one, whose name escapes me at the moment, and I'm sorry. Okay, so why don't we take a 15 minutes? I don't know, Dawn, Erica, how long? We have a fair number of ones to go. Are they controversial? Should we take a 15-minute break, 20 minutes?
There's one that's a little bit trickier. The other ones I don't think are, but
okay.
Maybe 12:30.
Yeah, why don't we do to 12:30?
May I ask a question?
Yeah.
Is the group comfortable to continue without a break?
Oh, and
so that we will finish earlier rather than, because I had said it, but I didn't want to personally, would rather just keep working. And then when we finish, we just go.
Staff, what's your sense?
I'm personally fine with keeping on going, but it's if people need a break.
Why don't we power through, and then if it looks like we're gonna get past like 1:15, 1:30, I need at least a little bit of a break to get some food, but I'm happy to power through and be done early. Herman, that's a good point.
Okay, and I let Erica Carroll know that I have just a half-hour call at 12:30, so I'm happy just to keep going through on these, and then
great.
All right. Maybe you'll be here and maybe you won't at 1.
Well, we're gonna do the vote at the end.
Then maybe can we take the harder one first, then, if we have Catherine's, the benefit of Catherine being here, the impact fund one.
Perfect. Let's do that, and then let's get Bob back too.
Yeah. So which page is the impact fund one on?
Vicky, do you mind emailing Bob to come back?
Sure, no problem.
Thank you.
And Herman, thanks for the suggestion. It's a good point.
So impact fund.
It's alphabetical. I should be able to scroll up and find it, right?
It looks like it's on page 80,
Right.
the California bar exam cut score one.
Yeah.
Yeah.
Okay.
Oh, this is an interesting one.
Erica, do you want to summarize it?
I think you reviewed this one, didn't you?
No.
Okay.
Oh man, no, I wasn't the one that pulled it out.
Okay.
That's the same. They're a qualified support center, right?
Yes, they are.
And they're
Yeah.
working with other qualified legal aid organizations like Central Cal Legal Services, CRLA.
Yeah. I don't think that the advocacy activities even require them necessarily to be partnering with a QLSP, as long as it's of benefit to, the work of the QLSPs in general.
They partner with a QLSP though? Doesn't
Yes,
that-
that's my point. They did. Their partner organizations include Central California Legal Services.
So isn't that the end of the inquiry?
That's exactly where I went, which
Yeah,
was
sorry.
different than what we just decided on the other one.
Yeah.
Like, the standard isn't about, I get the questions about, is it indigent or not sufficiently? But I guess help me understand what the staff's question was, because
I feel like this might be a mistake. Erica, is this?
the area legal aid,
All right.
Asian Americans Advancing Justice, there's a whole bunch of QLSPs here.
Yeah, I think it had more to do with the nature of the work, whether,
Are they not providing professional services? Because it has to be professional services to a QLSP or direct representation of an indigent client, right?
So it was a detailed letter to the California Supreme Court, which seems like a professional activity regarding the effects of the arbitrary cut score for applicants of color as well as communities without access to enough lawyers.
yeah, I think it had to do with the fact that even if QLSPs were supporting the activity, whether this is actually benefiting the work of the QLSPs, like, is this benefiting the work that they're doing to provide services to indigent Californians, was the, like, it is clearly an advocacy activity, but whether it's actually, helping the QLSPs do their work in terms of their primary purpose of providing services to indigent persons.
I mean, it's an access to justice issue, but there's like a step in between. It's basically if I'm understanding it correctly, the challenge is that many of the would-be lawyers who would be serving in the legal services community are being harmed by the way the bar exam is being scored. Is that right?
Yeah, I think that's.
And I don't know what their data is to show that those folks who are harmed by the way the exam is scored would necessarily be legal services attorneys. Oh, I find this a little stretchy, even though I personally might like it. I have to take a leap of faith on some of this.
Okay. So just to make sure our record's clear, and is this letter to the California Supreme Court, we think is not a professional service in support of a QLSP. So that wouldn't require indigency. Instead, it is a direct service, which would require an indigency. And then to Kim's point, the indigency is an access to justice, might help people, but it's a little bit stretched out, right? I just want to make sure we understand staff's.
That sounded like what I said, but I'm not sure if that's what how staff reads it.
Yeah, sorry, I didn't mean to repeat it.
Yeah, I think the difference is that it is a support service. They're engaging in legal advocacy. I don't think I would look at this as direct services, but whether it's helping QLSPs whether it's for the benefit of QLSPs and the work that they are doing and providing services to indigent persons, I think that was the question that was coming up. Like, this would be a benefit in general based on their explanation to the bar in general. But
I see.
I mean, to me, it's interesting because, you know, like from my experience of legal aid programs, hiring people from diverse communities to represent your client population, and we hire people out of law school who then take a leave to go take the bar exam, the disproportionate impact on people who don't pass the bar is, I mean, it has an impact on a direct impact on legal services programs, because it impacts your ability to recruit and retain lawyers to represent the clients, and means that you know, at some period of time, you're not if they don't become a lawyer, that's a different problem. And then you have to potentially like let them go and hire other people, and you've lost the benefit of the period of time that they're there. So I guess that's, to me, the benefit to the qualified legal services program. But I can't say that that's how they framed. I mean, I don't know if that's how they framed things in the kind of in the letter. Pamela's like, it would have been helpful to see the letter. I have to agree with that.
Great point, Pamela.
But am I hearing that people are comfortable with this activity? Or
Not necessarily comfortable
not
with it.
necessarily? Okay, because I thought
Yeah.
I heard from the beginning that, okay.
I have a personal
I'm
view on it.
probably comfortable with the activity, but that doesn't mean it should.
I mean comfortable as in, do you think it's qualifying?
Yeah.
Well, I will just say for me, I think it depends on what standard. This is saying a nexus to indigency, and I am a little
Yeah,
concerned that
I think that's misleading.
okay, but that's not actually the standard by which we need to assess it.
Right.
It's either an indigency issue, or are they supporting the QLSP? And the indigency is pretty attenuated. I agree with that. Whether this letter supports the QLSPs is also an issue, and that's where I think we're trying to get to, right? I mean, I guess the issue I have is maybe this isn't like a primary purpose thing, but like lowering the cut score helps big law firms too, because if their people don't, like, they hire people right out of law school, those people, you know, so is it just, but they can get more people, you know what I mean? There's a disproportionate.
So we're also, I called up backup because Dan is the one that elevated this, and he was in partnership and with Elizabeth all day. So Elizabeth and Dan are logging on literally right now. And he'll explain why we pulled, because I think the nexus to indigency is attenuated. That's not the standard for support centers. So I think that is misleading. So what I'm hearing is, are we in agreement that this is a professional service, this advocacy? My personal is that it is.
I agree, it's a professional service.
Okay, so we're in agreement, it's a professional. We're in agreement that this is an indigency issue. So I guess I am also struggling on why it was elevated. Erica, can you say it one more time?
There is Dan.
Oh, there's Dan.
Dan and Elizabeth have just joined.
Great. So
Hi.
Dan, Elizabeth, this is the California Bar Exam Impact Fund case that we're actually having a hard time figuring out why it was elevated. We've concluded that we believe that this is an advocacy activity, that letter constitutes a professional service. We've also in our agreement that support centers don't have the same standard of indigency. So I guess our question to you, Dan, is why it got elevated.
What they're saying is that this was a service to help indigent people because it would help attorneys, it would help increase the number of attorneys and probably the number of attorneys who weren't, white male attorneys, and that those people were more likely to provide services to indigent people. That was like 3 steps of connection of our, connectivity in that nexus. And that was farther than staff felt we were authorized to take on our own. You had to assume that this change would help people who were, either minorities or not male, and that B, they would want to do pro bono work, and that C, that would be for indigent people.
So Dan,
So,
one
yeah.
thing that we were trying to highlight though is it seems as if for the support centers, indigency is not actually required under the first prong. So is there a concern this isn't a professional service to a QLSP?
No, it was a concern regarding the nexus to indigency. There was no clear sense that there was a QLSP involved, but if this was considered to be something that helped indigent Californians seeking legal representation, then it would be an activity that would generally be helping QLSPs. We just didn't see that connection very clearly.
No, but Dan, I guess what we're saying in the committee and the conversation that we've been having and what I've represented to the committee is that we haven't required support centers to demonstrate indigency. We don't have a site for that. Where are you getting the site that we are requiring indigency for support center activity?
And I'll also note, they say they partner with a lot
with QSPs
of organizations that do qualify as QLSP. So are you saying that by partnering, that's not providing professional services to a QLSP, so they wouldn't qualify under the first prong?
We see that they are partnering with a lot of QLSPs. They don't identify this activity, and no one else seems to be working in this area. The connection is again one that we haven't as staff made. The numbers, for example, we could look at a case regarding transgender individuals and see that there's been significant, substantial arguments about why this would be a big impact on a lot of indigent people. But this one didn't make that kind of an argument. It suggested that by increasing the number of lawyers and the number who were diverse, we would be changing the services available to poor people. And if there's no requirement that there be a connection to indigency, we really, I guess, don't have a reasoned argument against this. If there's no concern about indigency for a QLSP, for a support center, then staff's concern has been resolved. But it is a step farther than we've gone, and that seemed like something that we didn't want to do without bringing it to the committee's attention. I've just looked through the guidelines, and their role is to provide legal services and support. Doesn't say for indigent people. It says they need to do it for QLSPs at a significant level, and that we would be considering similar work in other states. But it doesn't have to be for indigent people.
By mistake, to be completely honest with you, I think we pulled this one by mistake. Because if
indigency is not an issue, then I think that the staff concern, it has been resolved.
Like I said, assuming that you guys are in agreement that it's professional services to a QLSP, if you think that is in question, Then
I don't think that's in question. I think
That's
we
not a
agree that it is
question.
professional services to QLSPs.
Okay.
Yes, that's not a
Then
question.
I think they would qualify under that, right?
Yes,
On what we talked about? Okay.
yes.
Anybody else on the committee have concerns about that? No, hearing nothing. I think we can vote to approve it, but I think it kind of, yeah. I guess we can move on.
Okay. So the rest should be more clear. Yeah, this was the stickiest one, but yeah, I think we pulled it by mistake, so we apologize for that. The other one should go pretty quickly.
No problem. It makes sense. It looks like a stretch, so.
I just want to go back to, we skipped over public advocates, low-income student advocacy. This is another activity that 2 years ago was found non-qualifying, I believe, for a lack of data. Last year it was found to be qualifying. The reason it's elevated this year is because the activities have evolved. So last year, I believe there was more emphasis on, enforcing certain regulations or getting legislation passed. This year, it moved more into providing support to students building coalitions. I believe they produced a report on a program that was funded or altered by some of the prior legislation they supported. So it's under the same heading, but again, this is another example of an activity that's kind of been changing slightly over time. But the justification for it is the same as what, or very similar to what was presented last year.
Okay. This is page 87 in the memo.
Is there any reason they're using, if I'm reading this correctly, 2015 to 2016 data? I'm going to make some assumptions that the number of people who may be below the 125% would probably be higher than 42% now, based on what has happened in the last year or last 2 years.
I'm not sure, but it looks like Will Roscoe from Public Advocates is on the call, so I can let him maybe respond to that. Will, you're
Give
unmuted
you
if you
permission
want.
to speak.
Yeah.
Hi, thank you. The 2015-16 data is the most recent currently available. We checked that. We secured this data by hiring a consultant last year to do the research. There is not data on Herman's question. It is a belief that low-income students have been disproportionately impacted, especially at community colleges, by the epidemic. The concern of the advocacy is access to post-secondary education, and that is being undermined in the present economic situation.
And that's I think that number is a little bit higher than 42%. And I appreciate the fact that you said this is the latest data. But just depending on what happened and what has happened in the last year or so, I know several of my students were impacted by what has happened. And I don't have any data to help you, but I just think that the number is higher than 42%.
Yeah, as in there's more.
Yeah.
More potential people who are being impacted by this,
Yeah.
who are indigent. Okay. Questions or concerns about this? Any information that maybe Will could answer questions about from the committee? I see no hands raised. Are we generally feeling like we would be willing to approve this?
Is this the same
Yeah, Pamela.
data that's provided on page 94? So I have a question. I want to make sure I have the correct. Is this the same connections 94? No. Working
94 is for their transit
the transit.
advocacy.
Okay.
Yeah, and then this one's about the low income students. Okay. Okay, unless anyone else has questions or concerns or wants to do further discussion, we can move to the next one.
So the next one was California Rural Legal Assistance, their census advocacy work. My understanding was it's related to outreach and increased awareness of the census and the importance of participating in the census when it was administered last year. And they stated that their primary focus was reaching low-income workers, agricultural workers, individuals in rural areas, and that they were focused on low-income zip codes. So the issue that was identified by staff was whether this would be considered a legal service. Not necessarily that the target population was indigent persons. I think that part appeared to be clear, but whether the committee would consider this to be a legal service.
And this was the census work. Last year we had flagged for the committee that we knew there were going to be more work around census work. And so the committee did direct us to elevate these types of advocacy work this year.
So there's no indication that they participated in litigation or lobbying, anything like that on this project?
That's correct.
Yeah, it's like a lot of public relations and media. And they didn't, I don't see anything indicating they were like advising people about their legal rights under this census.
Yeah, that it wasn't obvious from this particular activity. There is another census case that we're going to elevate from another organization where their argument is that this helps kind of like holistically their legal advocacy work and generally to the same population. And so that's why it should be counted. So if you buy that argument, then I would apply that here, even though CRLA hasn't proposed that particular argument.
So sorry, so the idea is we do outreach that gets us more funding. We're able to provide more services to our indigent populations. Is that the thinking?
I think the more of the argument is it's like a multi-pronged strategy, legal services, doing some census work. It's helping the same population.
Yeah, but
and that it
they're required to do legal work.
Yeah. I mean, this is why we're elevating it too. It's a little bit, yeah.
Pamela, you had some questions that you put into the chat. Do you want to ask those?
You can pose those to the organization. Yeah.
Well, if we decide to vote on this today, you'll want this information before we vote. Because I think
here, if the individual's online to address them, that individual can respond to all of them or a couple.
Well, Pamela, I can respond to your first one. How is this organization defined role? CRLA is, I think they serve very rural parts of, they serve a big swath of California. Many of the counties that they serve are undeniably rural. I don't think that's like even at question here.
No, because sometimes, I mean, before we were redefining the word, so I was trying to figure out now how are they defining the word?
And we have Jim Meeker, who we have the benefit of. He's on the Access Commission, and he did draft a report 10 years ago, Jim, or I can't remember, but defines rural. And can you confirm the CRLA squarely qualifies their service area as rural based on that definition? That's, I think, the standard now.
Yeah, most of them are in the MSSAs that are classified as rural or frontier. But
CRLA is an LSE funded program that serves primarily counties with a lot of farm workers. They cover the middle of the state, they cover the central coast. They have a very strong organizational mission and identity around farm worker and low income workers. And when I did a site visit there a couple of years ago, I was in Salinas and Watsonville and some areas that I think would certainly qualify for that classification.
So I guess the question at hand, though, is the committee leaning that this is legal services work or not? Because that's where we had a hard time.
it's definitely advocacy.
What did you say, Jim? I missed what you said.
I say it's definitely advocacy for more resources for legal work because we allocate resources based on census data.
So do you buy the argument then that it's legal services? Could you make that leap?
Well, I would argue that it's advocacy for resources for legal services.
Yeah, but I think we can only use legal services as qualified expenditures is the problem, right? Like they can do this work. It's just not going to get counted as if we don't consider them legal services. Louise, you also had a comment?
I think it's a hard, it's even looser than the last one in terms of getting to the qualifying end of the discussion. I mean, it's ultimate, if maybe they could give us some more information about how, once they have this data and more people are voting, therefore, blah, 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 how does it affect indigent people or how does it increase their ability to provide services? Something that has an endpoint that I'm not seeing the way it is now.
But I don't think the question is whether indigency, right? Because I think are we in agreement that they're serving indigent clients? I mean, this would benefit generally indigent clients.
Yeah, I agree. No, you're right. But I just don't see that. I'm not getting a clear enough picture, I guess, is what I'm trying to say.
But I guess my question back to you is if we went back and asked them, what specifically do you need in order to make a determination?
Do I need, you mean?
Yeah, or the committee, yeah.
What are the legal services
What-
they're providing to an indigent population?
And Dan, have you asked them that? Because usually, like I had mentioned to the committee that we provide, the staff is directed to provide an opportunity to programs to provide supplemental information. Has that been asked in that way?
Yes, I sent them an email, late last week, asking, letting them know that there was a question about whether this was a legal service and would they like to supplement the information in their report. And I got an answer back that they stand by their report.
Oh.
So do you want us to ask again then? It seems like Dan has asked. Do you want us to ask give them another opportunity?
I mean, look, if they're advising people on their rights regarding the census, like.
Yeah, if that was clear, we probably wouldn't have elevated it, but we can ask again.
I mean, they say that. They say their project was aimed at advising rural hard to count populations on their rights regarding responding to the census, explain the census.
But they don't say legal rights. They say unless, is that too fine of a distinction? If they had said legal rights, would that?
They are legal rights. I mean.
So then would do you buy it then? I mean, am I hearing that you?
Well, I mean, we're kind of talking it through a little bit. I don't know about the problem is like what they actually did doesn't sound like that, right? Like providing, I guess they did a walkthrough, but that's not really. So I guess the issue is, to me, there's a difference between advising people whether you're a citizen or not, you still are not only entitled, but should respond to the census. Here's how you do it. You can't get, there's going to be no penalties, right? That's different than going out and doing a PR campaign to get people to respond. And they say they advised. It's not clear to me. I don't know what their flyers said. You know what I mean? I don't know what, like, the masks don't say you have the right to respond to the census. So I understand the staff's concern. I have the same concern, which is saying you advised versus actually seeing it. But maybe that's just my view. I don't know what other people's views are on this.
I just don't get a clear sense of the purpose. Whether it's to give them, legal information about the census and their rights about the census, or, I mean, I'm not sure that's what they're doing. If that's what they're doing, I think I'm okay with it.
So we can ask them again, and then we can also ask for a sample of the flyer, a sample of some of the materials. Maybe that could be a bit more informative.
The goal overall was to increase turnout and participation in the census. Whether that required just a PR message or something more substantial, but this was about outreach into the community to get people to sign up. This wasn't about changing the way the census worked.
And then I think what's not said is that the trickle down then provides more services to those people because they get counted in the census. But I don't see that that's in here either.
But also it's not a legal service. Just getting out. Well, for me, you don't need to be a lawyer to do outreach on the census. You don't need to be a paralegal. You don't need to be under the supervision of a lawyer to do outreach. You might need a lawyer to potentially create some script about what the rights are. And maybe that might, be something, but outreach alone does not say to me legal services. Where it gets muddy is it looks like outreach, but they say they advise. What percent, you know what I mean? Like, I don't know, what percentage, is that enough? I'm inclined to not think it's legal services, and it sounds like, is staff, what's your take on this?
I think we were leaning that it's not.
Yeah.
But we wanted you to get your expertise but that was our leaning.
I don't know about how much police expertise I have. I'm just leaning. Other thoughts, other people, do other people feel like this should be a legal service, not?
I feel that it's worth asking if they would provide some of their materials and then making a decision. But in my head, I'm comparing this to a project where you were trying to encourage voting.
Yeah.
And that one is much more clear for me, that you are informing people of their legal right to vote. And participating in the census isn't quite there for me.
Yeah.
Maybe seeing some materials will help us. At least I found their response to Dan when he reached out to them pretty.
I was startled.
Yeah, really curt, kind of like,
that wasn't the whole conversation. We did have other things, and they're very courteous and cordial, but they were saying they didn't have anything to add to this.
Right. Yeah. It's interesting.
So
I think maybe the message is, it looks more like outreach than legal rights. And if we welcome we want to provide them with an opportunity to correct our impression if it's wrong. Bob, do you have your hand up?
Look, Dan has talked to them twice, and the second time he asked a repeat clarifying question, they said, our report stands. Why can't we take them at their word? Why are we second and third guessing them and saying, but what if we do this? What if we do that? They're coming to us for money. You know, it's like we're bending over again, triple backwards. They said the report stands. We ought to take them at their word. They're professionals. Deal with what's in the report. and make
Okay,
a
so,
judgment based on that.
so Bob, what do you think? Are these legal services or not?
I applaud what the agency does overall, but this isn't legal services. You know, somebody said earlier, like, I could go do this. Let me be frank, I could do some of this. So could some other people on the call. So no, it's not legal services.
So I didn't realize that Dan had reached out to them twice. That's kind of persuading me to think that maybe they think they're pushing the envelope also, and so they have nothing more to add. I mean, I'm kind of persuaded by political Bob that we can just make a decision and not go back to them a third time.
Yeah. And let me also say, if they wanna, they can always move to reconsider. Not that I want to invite that, but like,
yeah.
they really think that we got it wrong. They can come back and tell us, like, here's a bunch of our stuff. At which point we'll be like, oh, you should have shown it to us earlier.
Yeah.
Andy, if we go back to them a third time, that could set a precedent as other agencies find out. They could say, gee, you never really pursued this to the nth degree, you know?
I mean, that's fair, although we are trying to give funds to people in the legal services. So I don't want to, you know, I want to give them opportunities to address our concerns, but it's a good point. It's a good point, Bob, not to.
They've been getting money for us for decades, figuratively. You know, it's like they're professionals at negotiating, talking to with us and getting money from us. They're not newbies, you know, fresh incorporated in California, starting from scratch.
Fair point. You're right. Herman, what's up?
I wanted to ask Dan, is there a reason you went 2 times and you didn't get sufficient information the first time, so you decided to go back again, or what was the reason for going a second time?
The first time was just after my initial review of the document. I had some questions. I wanted to follow up and think it through a little bit more. When it got to the point where we were bringing it up on review, I wanted to bring that to their attention, let them know, here's the question that's going to come up on Friday. Do you have anything more to add?
Okay, and they said no.
That's right.
Okay, thanks.
Okay, cool. Well, I think if there's no more questions on this one, it seems like we've sort of gotten to a place where we think we have a decision on it, and we're not going to go ask them for more information, and ball will be in their court if there's some further concern. Is that, anyone dispute that? Hearing nothing, let's move on. Whoa.
I want to apologize for this. I wanted to share information that they gave us, but they gave us a lot of information. So,
do you know what page of the memo this one is?
I think it's either the first or the second activity and attachment
Right.
B.
Yeah, it's at the beginning.
Okay, oh, I see. Thank you, sorry.
Page 60.
63, yeah, okay, thank you.
So Asian Americans Advancing Justice LA, they similarly had a census advocacy activity that's being elevated. The reason there's so much text here is because we did get a response from them about the nature of the activity and why they thought it was qualifying. But generally, they also engaged in an outreach campaign, you know, bringing awareness and education about the census and the importance of responding to it and working with community-based organizations. And so when we asked them for more detail about the activity, they responded and said they felt that it was primarily benefiting indigent Californians. And as you can see, they provided some statistics. They also mentioned that their census work in the past has been historically found qualifying. I don't know if they meant specific activity as listed here, or if they just have done some other census work that would be more squarely qualifying as a legal service. But they did mention that they, I think, had prior experience with some of their census work being found qualifying. Go ahead.
Last year, they did some census work which was found qualifying. It was advocacy with the LA Unified School District to have them disaggregate census data, which would then allow them to target services more effectively to low-income people. It was, I thought, in that case, a more direct form of advocacy with an agency, with a branch of the government, whereas here it was harder to tell from what they've given us that the same kind of advocacy was taking place to get a government agency or some other body to make a change of some sort.
I'm curious if staff can distinguish this from the one we previously just said was not legal services.
I think that's a really good question. This one is packaged better for us in the response and the back and forth. But I'm not sure if that's just presentation though.
Right.
The only place where I'm seeing something that could be a difference is in the black text under Nexus. It's a paraphrase of their 3 advocacy successes, that they got better language access and cultural competency, that they got more money, and they extended the timeline. I'm not sure how much legal services were involved in these activities, but this is a like an outcome that wasn't part of what was described in the CRLA report.
And this is what I meant when we were on the last one, referring to this one, is that they do a better job in terms of, and they say, I mean, whoever wrote this, Black Texas, Dan or Erica, does a better job of like connecting it to their work that CRLA doesn't do in the other one. So I think that's a distinguishing factor.
It's pretty much their words, but they use more, so I just shrank it down to try to get it on this page.
Looks like Bob has his hand raised.
Yeah.
So
Sorry,
this,
go ahead, Bob.
this can be maybe several questions. First off, they mentioned multiple languages, multiple constituencies that have differing rates of poverty. There's something, I don't know, what's NHPI mean? That's an acronym.
Native Hawaiian Pacific Islander.
I thought so, but I've never seen that before. So that, and then this says Asian Americans Advancing Justice, Los Angeles, California census. Are they focused throughout the state, or are they focused just in Los Angeles? And is it Los Angeles County or city, or Los Angeles metro area? Do we know?
This organization has a primary focus in the LA metro area. They're looking to expand always, but their real concentration is sort of the LA urban zone.
Here's the questions I've got, and I wish I could say I don't have a question, but they're talking various languages. Do we know what are the required languages for census and what are the required languages for California? Because they mention languages that Los Angeles does not require voting material in Hmong, Hindi, or Thai. It doesn't, it requires it also in other, I'm going to say it, Asian countries' languages. Iran is in Asia, and Farsi is a required language in LA. So is Japanese. The definition of Asian has become really transmogrified, muddy, because again, Iran's in Asia. And that may mean that they don't have a poverty population significant and relevant. But some of the populations are clearly historically needing to have information in their languages. Others do not, I'm yet aware, legally required. The point is, would advocacy for getting those languages included when it's not required, possibly by the census, by the state of California, or by Los Angeles voting requirements, would that then mean that's extra outside the requirement of legal advocacy? Dan, I'll start with you, or I don't know who else. It's just like, should we fund Hmong, Hindi, and Thai language advocacy improvement?
You know, that's almost a legal conclusion. I really defer, but I do, you know, raise the question that language translation services don't strike me as meeting the definition of a legal service in the state bar rules.
Right. And there's no indication they advocated for the census to be published in other languages, right?
They just couldn't get it published in other languages, but they tried to get more translations.
No, but that one's kind of a legal service and one is maybe less so. Sorry, Jim, you had your hand raised as well. Oh, you're on mute, Jim. Sorry, we can't hear you.
I was looking at the quote that you have on the slide. It specifically says, while our census activities were not, quote, legal services as defined by the state bar, but it led to advocacy that benefits. I think you could say the exact same thing for CLRA in terms of their census work. I mean, so if we're going to say no to CLRA, I don't see why we would say yes to here.
Yeah, I agree. And that's why I was mentioning before, sorry, I wasn't more clear, that even though this is packaged well, I think it's a fine distinction. So if you say yes to this one, I think you need to say, to be consistent, yes to CRLA.
Okay. Other comments, questions? Pamela, you have a question.
Looking at their data here, so are they saying that their immediate audience in a neighborhood is that huge number? That's what's here in their responses in terms of available individuals impacted. So is that in their immediate neighborhood?
No, that number refers to the people across California who would be benefited by this indigency, by this advocacy. And then their direct outreach and language resources are going to be concentrated in the LA area. It's hard sometimes to get a consistent sense of how people are describing the scope of their services. They want us to see them as big.
So I guess are people in agreement with that last point that Jim made that I agree to? Like, if you did not approve CRLA, so for consistency's purpose, I think you don't approve this one, or is that an overreach?
Agreed.
Okay.
Anybody else think differently? Yeah, I don't see anything, like I said with the last one here, where we're seeing like advocacy with like state or federal legislatures, right? You know, it mainly seems to be an outreach thing, which I commend them for their work, but I'm just not sure it falls under our statutory requirements for qualifying expenditures.
Yeah. So we'll let them know if I'm hearing some consensus, and then if they choose to, you know,
they want to move to have us reconsider, we can certainly to discuss that with them.
Yeah. And then if they do, then
ERC or something.
Yeah. No, and if they do, then we'll we can move them to an ERC and then give them the background of our discussion today. Okay.
Perfect. I mean, they're recorded, so they can see. All right, what else do we have?
So Asian Americans Advancing Justice Asian Law Caucus had a redistricting advocacy effort that they were working on. And so the concern is not about it being a legal service. The advocacy aspect is clear, but whether redistricting for voting can properly be argued to be disproportionately impact indigent persons was sort of the main question that came up. They definitely, put forth their argument, but I think staff still had a question about whether it was sufficient, because this is something that truly would impact just all voters across the state. So.
Do people have thoughts on this?
Almost ready to send them to you. Hold on.
I think at least in mainstream society, depending on how you redistrict, it could cut both ways, but being that they serve low-income communities, I guess I personally would lean that this is qualifying, because it would probably disproportionately help our kind of low-income and underserved communities. Dan, Erica, is that, I can't recall the staff leaning. But.
My own leaning was, this is a really hard call. We're talking about a very broad impact. And I think that you make a good point, Duan, that it's likely to cut in favor of people who are traditionally disenfranchised. So if that's sufficient, then I would be comfortable, if this got approved, I wouldn't have any problem with that. But it's a sort of a judgment call. This is right on the line, I think.
I agree.
Okay, Bob, let's do yours, and then Pamela, let's get to your questions.
So a lot of previous advocacy about redistricting was how poor people and people of color were marginalized by the way districts were gerrymandered. And so the idea of bringing in the redrawing of political voting districts is relevant to making sure that one man, one vote prevails, no matter what one's income level is. That I'm willing to accept and support this. I know it makes you feel it's not slam dunk, but by also reducing the waiting periods for community groups to participate in redistricting, that also helps make sure that all who have an interest in this issue and want to speak up, can do so. I'm going to accept this and go along with supporting it, but I'm not cheerleading for it.
Okay, thanks, Bob. Jim, what's your view? I think you're muted.
I had sort of the opposite conclusion to this. I mean, redistricting is not done by the legislature anymore, right? It's done by a third-party committee that's made up of both Republicans and Democrats and independents. So you don't have the gerrymandering that favors one party or the other anymore, as I understand it. So it's not clear that we have a history of gerrymandering that disadvantages the indigents like you have in other states, like say Wisconsin. So I don't see the connection.
The Citizens Commission is not permanent. There's been recent statements that the legislature could take it back and do it itself again, or come up with some other formula or approach than the current Citizens Commission. So this request for funding could help buttress and support the current Citizens Commission, as I call it, and reduce the chances of it being brought back into the legislature for political shenanigans and finagling.
Bob, if I understand correctly, that commission is in existence for another 10 years. The first commission came out in 2010. They just selected the last recent 14 people, which will go from 2020 to 2030. So I think it's a legislative mandate that that occurs.
But the legislature could still withdraw that. But I'm saying it's not
Right.
permanent.
But
Anyway.
the bill that they are advocating, what did it do? I'm sorry, I'm like looking up AB 1276.
This is a really technical bill, and it ties to an SB 983 or something like that that came out last year that this organization also advocated for and ultimately pulled its report on it. So we didn't talk about it. But this has to do with the rules around the way that you redistrict, that the community participates in redistricting when it's a charter city. Apparently last year's
Oh my gosh.
legislation had some errors and omissions in it, and this is designed to fix those and shore up some things that should have been included. It's super technical.
But so I'm sorry, it's Catherine, I rejoined, but none of, isn't the, I don't think how the question was, right? How, this does not just benefit indigent people, right? And I don't think you could say it half benefits indigent people. So isn't that the question we have to resolve in this eligibility review is this something that benefits eligible people? And if not, I'm sorry, it might be great work, might likely even like support it, but it's not something that could be a qualified activity.
You know, there are different standards that have been used here. The predominant or principal impact is one, and then there's also the disproportionate impact or impacts a significant number or particularly impacts. So, you know, the things that come out into individual review have been raised because we're not exactly sure how to resolve this question.
Uh-huh.
Sure, but sorry, I just to echo Catherine's point, it's like if this is a hyper technical bill, just because it may affect redistricting, but doesn't actually, like, are charter cities particularly run by or are indigent populations predominantly in charter cities where fixes to that redistricting might like disproportionately affect like those, you know, an indigent population? That isn't very clear to me. So I think, Catherine, that's kind of what you're.
Yep, I'm just, sorry, interrupting all of you because.
No, you're fine. Jim, you have your hand raised?
No.
Oh, I think it's still showing. Other, sorry, and then
the charter cities in California, if you want to know, are Adelanto, which would be probably poor, but Alameda, Albany, Alhambra, Anaheim, Arcadia, Bakersfield, Bell, Berkeley, Big Bear Lake, Buena Park, and Burbank. So I do not think there's cities that are
right.
have a higher percentage of.
San Francisco's a charter city.
Is it? It's not, was it? I just Googled it, so it
sounds like you got through the
not
bees.
appear.
We've been a charter city for eons.
Well, perfect.
Sorry, Pamela, your questions. Do you want to, should we look at those?
You can. So the data that they're supposed to be supplying to us is data from 2020.
Mm-hmm.
Where we're actually flexible and firm and just kind of be considerate. So is this data that they're proposing 2020 or is it prior year data?
I think that my guess, and I don't know, maybe Dan is the one, but are you talking about the number, your A? I think the 38 million is again the state population.
For what year?
Oh, I don't know. I'm just assuming because the other one also used 38 million. Yeah.
One of the challenges with a lot of these activities is it's hard to get really good data that's up to date. So they're using pretty broad statewide numbers to talk about the impact of this broad statewide policy effort.
I just also want to do a time check because we're approaching 1:15. Erica, how many more cases do we have to go
Yeah.
through? This is the last one?
Yeah.
Oh, this is it? Okay.
And then we
Okay.
just do our vote. Okay. Let's power through. Got it. So we don't know what the number is. We think 38 million might be statewide population for a year. And then Pamela, you wanted to know what their work on AB 1276, the effect on their fiscal budget. We don't have that information at this point, right?
Like how much money they contributed to this effort?
Yeah, like how much?
They have an approximate hours, right? In the report, I think report they have to say how many hours.
The advocacy activities don't require it.
Okay.
Okay. And then Pamela, you wanted to know if gerrymandering and redistricting was part of their primary purpose?
Right, so what is their primary purpose state versus, and how's that compared to what they're proposing?
So Asian Law Caucus is an organization that's really dedicated to protecting the rights and interests of the Asian and Pacific Islander community in general, and in particular those who are not reaping the benefits of being in the United States, those who are indigent or who are otherwise being left out. So the idea of empowering this constituency is consistent with what they do. They're not like a voting rights and census participation organization. They're a community empowerment organization, and this is part of that.
Cool. And then how many new cases in 2020? Do you mean on this issue, Pamela, or generally?
Because the whole of 2020, a lot of things were put on pause. A lot of things we were asked to allow carryovers. We were allowed to pause things. We had a lot of considerations. So again, we're supposed to be addressing issues that occurred in 2020. So how many cases did you incur for 2020 that would help us to help you?
Well, in this particular instance, this was, a very far attenuated, kind of disconnected relationship to those, because this would be advocacy to correct a bill that would give people rights that if they were violated, then they could have a lawsuit, but we haven't gotten there yet.
And then your last question was about the federal government is fully funded and resourced to market the census. How much of your budget in dollars was spent on this endeavor? I'll just note this one's not on the census, it's on redistricting. So I don't know if you still wanted this, if you still wanted the same kind of question, but as to redistricting.
Absolutely, whatever, because they keep, it's like, if you can, I'm sorry, I mute myself. You can utilize the question for gerrymandering, for the census, for how this particular, how much they spent on handling that project. So yeah, because it's like if you're doing double work, the government has already have advertisement, marketing. They already have this mapped out for the whole of 2020. You saw commercial after commercial, letting people know that it's an okay thing for you to complete the census. Whoever's in the household, you can count them. There's no penalty to anyone in the household. So they kind of kept making that very, very clear. So
Yeah.
that's my point to how much did they spend on that same effort.
Well, I think, and Dan, you can correct me if I'm wrong. On this one, I don't think it was marketing. I think they were lobbying the legislature.
Yeah,
Not doing outreach to populations about the gerrymandering, but maybe
that's my understanding as well. This was really work happening in Sacramento with some other legal services organizations to get the legislature to pass this bill and clean up the Fair Maps Act.
okay. Thank you. Jim, is your hand raised?
No, I had my bid on redistricting at the beginning of this, so.
I think your hand raised button. Oh, there we go. I was like, it was still on, and I would like move down and then come back, and I just wasn't sure if it came back on. Okay, other thoughts or discussion that we want to have? Where are we leaning? Are people leaning like this has a sufficient nexus? Not. How are we feeling?
I don't think the bill that they worked on I don't see anything that shows that significant impact on indigent communities. I think it is a benefit to communities to be involved in this, but I'm not sure that I see it as affecting the target population in a significant way, the IOLTA target population in a significant way.
Okay. Other thoughts? Thanks, Catherine.
I agree.
Okay. Louise, I see you nodding.
Yeah, I agree.
Herman, Pamela, you guys, yeah, you think not sufficient nexus to indigency?
Not, no.
Okay. Herman, you same? Okay. Who am I missing? Am I missing Bob?
Probably. Yeah,
Let's move
I mean,
on.
I hadn't read through everything on this, and I didn't know if they addressed really what Catherine spoke to, which is that it disproportionately favorably benefits indigent communities. And if they didn't do that, then I guess I'm leaning with the majority, but this is a tough one for me.
Okay. Bob?
Doesn't sound like they
sorry.
did what to me is a critical point.
Let's move on. I'm just not willing to go fight for this.
Fair enough. Okay, so I think this was the last one, Erica.
Yeah, the two other activities that were in the meeting materials were removed from the list because we didn't.
Okay, I was just gonna ask about East Bay, so you removed East Bay, you removed.
Yeah, staff did a second pass and found that they didn't need to be included, so just didn't want you to think we overlooked them. They just don't need to be reviewed by the committee.
Great. So it sounds like we have two that we're gonna go get more information, right? That's cancer policy advocacy and
National Immigration Law Center.
yeah. And then we're approving the two public advocates ones.
Yeah.
With Bob recusing
With
on the first one about
that we're not taking the
Transit.
vote. They're just going to get more information. So, but
Okay.
so we don't need
He
a
said on the public advocates one, he's recusing himself from the transit one because he's part of that coalition.
Oh, sorry. Okay. Thank you, Catherine. Sorry, Bob.
No problem. I'm reading Bob's mind.
Yeah,
Remember.
thank you.
Okay, so Bob's recusing out of that one. And what else and then we're rejecting the two census ones and then this redistricting one. And then am I missing one?
I think Impact Fund we also pulled from, so.
Okay, impact fund, we don't need a vote.
Yeah.
Because that one's just going to be approved under the statute.
Yeah.
Okay.
Yeah.
Great. So it sounds like we have two motions, maybe
I need those to be super clear.
three. Huh? Pam?
I
What's
need
up?
the name of the organization, to help me, the name of the organization, and based on the actual page number from the day that we received, that will kind of help me to make sure I'm not saying the right things.
Okay.
I would need a minute to look up page numbers if you want those included in the motion. So I don't know if you want to take 2 minutes.
We made some
No.
adjustments.
I don't think we need the page numbers.
No, I don't
I
think we
agree.
do either.
They were helpful when we were discussing it, but I don't think you need it for the motion.
No, I don't want them in the motion. No, not at all. Not there.
Okay.
Because we've made so many adjustments. I just want to make sure that we're saying the right thing for the
Yeah,
right.
Erica's she's just gathering right now. She'll pull up the motion, but we won't include the page numbers.
But when we refer to which one, Pamela, for your benefit, I will tell you which page number we're referring to for each one. Does that sound good?
A few that I had comments about. So I didn't do everybody, but I just had a few that I had questions about. So I just want to make sure that my responses were accurate.
Okay. Thank you, everyone, for the time and energy today. These were some thorny questions. And thank you to staff for going through all these iLaw reports and raising for us some very tricky questions.
Erica, thank you for allowing us to continue without taking a lunch break. I think we'll finish up in about a half an hour, in about 5 or 10 minutes. And so hopefully you'll get a good lunch between 1:30 and 1:30.
Yeah. No, yeah, it made a lot of sense. I just wasn't sure if we were gonna go all the way to 2, and I was like, but I had a little snack nearby, so I was able to sneak a little bit. Oof.
Dan, I think you mentioned that the redistricting one might implicate other organizations. Is that accurate?
I think that Advancing Justice ALC Los Angeles was also cited as a partner, and I can reach out to them.
Okay.
Great. And I don't know if I speak for the whole committee, but at least for me, I would just, when we inform any of the organizations that we didn't accept, like, I commend them on the work they're doing. The issue is just, it doesn't meet the definitions that we have for counting them. So I just want to make that point. And
yeah, I think
But
that's
definitely we'll emphasize that when we provide them notice, and obviously if they want to have us reconsider, then we'll elevate them.
Yeah, no, absolutely. But I want them not to feel like we were, these get into this like, wow, it's not really, but at the end of the day, like I always admire the work that all the legal service organizations are doing.
This doesn't speak to the importance of the work or the good outcomes achieved. It's simply a review about whether this can be used as a qualifying piece of work for under the existing guidelines. The work, I agree, is impressive.
So where are we in terms of process? Don't we need a vote?
Yes, Erica's putting together a motion or something for us, I believe, Erica Carroll.
Yeah.
And she's going to share a screen right now. Look at her be so speedy.
Somebody's going to have to read. I can't read that. That's much too small.
Yeah, I think she's enlarging it right now. Everybody just give her a second.
And you can move all of us off to the right by moving your cursor. I always make my screen bigger, so I just can't see people, but it's okay.
What did you say, Catherine? That sounds.
You can. I make mine bigger by there's a little line down that shows where the people are and then where the shared screen is. And in the middle of that, you can move all the people to the right or whichever side yours are on, and it makes it bigger too.
I just did that. Perfect. Thank you.
By the time we're all done with this pandemic, we'll just be Zoom experts.
And hermits.
Erica, do you want to read the motion or do you want me to, or?
Sure. So my understanding was you wanted to take it as 2 separate motions. So the first one would be the committee approves the following impact litigation and advocacy activities as qualifying activities for purposes of the 2022 IELTA EAF application. And those activities are public advocates, transit, equity advocacy, which Bob is going to recuse himself on, and public advocates, higher education, low income student advocacy.
Oh, it was also impact fund too, Erica?
I thought that was just pulled because,
Oh, pull, okay, so we don't have to vote on it. Gotcha, okay, gotcha.
and then, sorry, go ahead.
Oh, sorry, I just wanted to say, for Pamela's benefit, the transit equity advocacy starts on page 92. And the low income student advocacy is on page 87.
Okay. And then for the motion for the non-qualifying activities, it would be the committee finds that the following impact litigation or just advocacy activities are not qualifying for purposes of the 2022 ILT EAF application and must be deducted from the organization's qualifying expenditures. And the three activities under that are California Rural Legal Assistance, their census advocacy work, Asian Americans Advancing Justice Los Angeles Census Advocacy, and Asian Americans Advancing Justice Asian Law Caucus, their redistricting fixes to the Fair Maps Act advocacy work.
So it's Catherine, and it was because I was gone. Why, can somebody give me one sentence about why the the two census ones are not considered qualifying, just so I know what I'm voting on?
We agreed that based on the evidence, based on the information the two organizations provided, their activities were not primarily, they were outreach and not legal services, because there was no lobbying, litigation, that kind of thing. It was essentially outreach to get people to participate in the census.
Thank you.
And Jim, you have a hand raised?
Yeah, what happened to the ACLU Immigrant Rights Project, the Muslim ban?
We're following up with them for more information for the next meeting.
Okay.
I think there's a third. Oh, no, we don't have a motion. We're just getting more information on those two, right? We don't need to motion anything for that.
Right. The other one is the cancer advocacy.
Yep.
Policy. Pamela, do you need the page numbers for those?
You're
Sorry,
on mute, Pamela. If you're,
I can't hear you because I think you're
I'm
on.
sorry.
No, it's okay.
So which ones were you referencing right now?
The ones that we're going to reject.
Oh, I have those
That
already.
are not qualifying. Do you need page numbers for those?
I have that already.
Oh, okay, great. Okay. Let's take these one at a time. Does anybody want to make a motion on the first one?
Catherine moves.
Okay, a second.
I'll second.
Okay, Louise. Per Bob's point, any discussion or debate on these? Hearing none, I think we can go to a vote.
Sorry.
No problem.
Connolly,
Yes.
McLaughy, Fightmaster,
Yes.
Bennett,
No.
Blakemore,
Yes.
DeBose,
Yes.
Delfino,
Yes.
Friedman, Nan, Meeker,
Yes.
Planthold,
Yes to the student and abstain from the transit.
thank you. Savage,
Yes.
okay. So we have 8 for the student and 7 for the transit and 1 no for both and 1 abstain as to the students. So the motion passes.
Thank you.
And do you want me to bring that back up, the motion, or?
Sure. So we know, we can see it before. Thank you.
Mhm.
Okay. So as to the second part, where we will find these 3 activities not qualifying, anybody willing to bring the motion?
So moved.
Okay, Bob,
I'll
Anyone?
second.
Louise? Any discussion? No, I think we can move to roll call vote.
Connolly,
Yes.
Augie, Master,
Yes,
Bennett,
Yes,
Blakemore,
Yes.
Bess,
Yes,
Delfino,
Yes.
Friedman, Mann, Meeker,
Yes.
Lantold,
Yes.
Savage.
Yes.
Motion passes.
Great. Whew.
Erica, there's one more thing that I just want to highlight before we adjourn that was mentioned in the memo. There are a set of expungement activities and kind of related collateral activities that was mentioned in the memo that our staff is suggesting to table for now. We won't be able to go back to eligibility for this because the next eligibility committee meeting, my understanding is right before the commission meeting, and it's a pretty meaty, controversial topic. So staff is going to be preparing a memo, and OGC is preparing also a memo with legal analysis that we're going to just bring straight to the commission.
Yeah, this was an issue about whether expungement activities are civil or criminal, correct?
Yes,
Correct.
and how to deal with them. In the application, whether to count them as qualified expenditures.
Okay. And you guys will, for our next meeting, we'll be dealing with the other two, right? The immigration advocacy matter, and with the out of state, the sports center, and the cancer policy advocacy, right? Those are the
Yeah,
only.
and we're also starting, so next Friday is when the 2022 IELTS and EF applications are due. And so Erica Carroll in our office is doing a training for all staff, and then we're going to start reviewing the application. So if there are any issues in that kind of initial sweep, we'll bring back to you. What we usually do is we do to make sure that, the audit's in, the audit's correct, final, some of the baseline issues. And then if we get further, then we'll try to tackle as much as we can.
Great. Okay, anything else that we need to address in this meeting?
Move to adjourn.
Sounds like we're good. Thank you all very much. And Herman, good
Thank
suggestion.
you, everyone,
Gotta
and
be here early.
thanks to the State Bar staff. Really
Yes,
totally.
nice work,
Great.
all of you.
Thank
Good
you.
job.
thank you very,
See
very
you
much.
next time.
Bye.
All right. Okay.